You're rocking with the best. You're rocking with the best. You're rocking with the best. You're rocking with the best.
Started out with a stack of bills, hand-me-down suit, no fancy skills. Library card, late nights, cheap coffee, highlight ink on every page he copied. No letters on the wall, just notes on the floor. Scratch math running down the old front door. Every question that the others left fade, he turned into a rule and a plan he made. Time to start to teacher, build it all from broken pieces. Read the books, the words got weaker. Turn confusion into secret.
You're rocking with the best.
Who's the man behind the speakers? Tell them that's my quiet leader. Time to start a teacher's teacher. Yeah, he can turn a red line black in a week. Balance out the numbers while he barely speaks. Spreadsheets open like a map of his mind. Sees a hidden pattern where the rest go blind. Court dates circled in a second-hand phone. Drafts every filing like it's carved in stone. Plain white paper but the case shines through. Judge starts seeing what he already knew. Time to start the teacher. Build it all from broken pieces. Read the codes, the words got clearer. Found the cracks and closed the leaks in. Reform each line, each feature. He's a quiet, heavy thinker. Tell him that's my steady leader. Time to start the teacher's teacher. No cap, no down, no.
You're rocking with the best.
But he wrote every page. Self-taught, self-made, self-drive. That fire turned out into something higher. We don't just follow, we climb behind him. He draws a map, we rise inside it. Time to start the teacher's teacher. Build it all from broken pieces. Turn those late night scrolls and research into freedom, into defense. When they ask who shapes the future, who we call when things get deeper, we just point and say our leader. Time to start the teacher's teacher. Started with a stack of bills, now he's signing better deals.
You're rocking with the best.
To the speaker, time to start the teacher's teacher.
But they were in his classes. They didn't even know. They had to Google it while we was live. So you're teaching people about Forms 1099B and none of them knows the regulations that govern them? But as soon as I bring it out, now people want to start reading the regulations. I swear to God, when I say I'm your teacher's teacher, I'm your teacher's teacher. The question is, if all these gurus on social media got the sauce, why aren't they attracting professionals? Professionals in those fields where they could come back and be like, yeah, what he's saying is absolutely right. None of them got professionals behind them, so it's all a theory. It's a belief system. That's all it is. They ain't got no professional they could be like, yo, you're right. None of them. They don't give a damn about what, give a, someone on TikTok and social media.
What it is that I want to tell the class and whoever that's listening is that if you pay attention to the things that he teaches in this class and start taking notes, do your homework. You know, he can only lead a horse to water, but he can't make it drink. You have to drink yourself. Missed 85% of the classes and stuff, but I had the core things and the core principles down, and I read whatever he put out there. I throw it on my iPad and just start scrolling and reading,
Who securitize their contracts or receivables? Why is it that all of them follow the same so-called rules. They all use the same script. They all file the same forms. They file all the regulatory form. Now, they may be deceptive as hell on those contracts, but why is it that if this was so many different ways to skin the cat, why are all of them following the same method? If it was 20 different ways to skin the cat, why is all of them following?
That's my teacher. That's my teacher's teacher, my God. He's a genius. Finance. Core filings. He really got the ball rolling. Hey.
He don't have no background, it's all self-taught. These online gurus, they all copy his style. He said, Thomas, lead the team, let's go to the top. Thomas, lead the team, let's go to the top. Thomas, lead the team, let's go to the top. Thomas, lead the team, let's go to the top. Thomas, lead the team, let's go to the top. Thomas, lead the team, let's go to the top. Thomas, lead the team, let's go to the top.
Welcome to the New Culture Empire livestream broadcasting live on YouTube. In today's session, we will be reviewing a court case involving an attorney and the use of AI. Also, we will be reviewing another wet ink signature claim. Please be advised that all opinions of Thomas are his own and are in no way to provide legal assistance and assumes no liability for any actions, results, or outcomes from the opinions expressed in this live stream. If you are interested in legal assistance, please send an email to thomaslegacy603@gmail.com. All services offered will be available upon request. Don't forget to like, share, and subscribe to the New Culture Empire on all major social media platforms. And don't forget to subscribe to the new channel, Drama News.
Run it up, run it in bang. Whipping up, he got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, I can't claim. You look like you wanna let go straight. What's up? I thought so, okay. I'm back in this symphony, stuck on the band. What's up? I thought so, okay, yeah.
You're rocking with the best. You're rocking with the best.
Yes, sir. We are back in the building with another. Woo! We have this. If I could just sum it up on what I mean, this would be the perfect show. Once again, we are going to unpack and address why. Not saying you got to listen to me, but why you should do things the correct way. And the correct way, it's not my way. It's the court's way. And it's the rules that were already set up before me. Hey, if I got to follow the court rules, you got to follow the court rules. There's no secret rules for sovereign citizens and rules for everybody else. If we got to pay our bills, they got to pay their bills. Or if they can legally prove from a legal standpoint why they're not entitled to pay their bills, when they signed a binding contract, when they already agreed to the terms, then unless they're showing that, you're going to pay them bills or they're going to come take you. You know it. So if you can't legally, from a legal standpoint, prove that you're not entitled, then yes, you got to pay their bills. Now, I know that's unpopular because most people thought that this was a place to come to so you don't have to pay your bills anymore. This is a place where you come to when you're in financial turmoil and financial dilemmas, and you can get out of your obligations, but you can still keep the property. Oh, they thought this was a place where you can come to, where you can have your cake and eat it and just have it go all your way, one-sided. I know. You needed to believe it. I know. You wanted to believe it. I know for most people, you have to believe it. Because there's no other way. But I'm here to tell you today that if you want to lose everything that you have, continue to believe it. Now, excuse me for a second, because I have to call a professional attorney.
Hello, Jeff Gamble.
Yeah, Mr. Gamble, how you doing? This is Mr. Thomas again.
Hey, Mr. Thomas.
Hey.
I was just emailing you.
Oh, okay. All right, perfect. I just wanted to make sure you you received it, and if there was anything.
No, I didn't get it. Did you send me a document?
Yes, I sent it to your email.
Oh, okay.
Hold on, let me make sure it actually went through because it said sent. Let me check my sent messages. 1 second.
Okay.
Yeah, 227 to the email. Let me
I'll open my spam filter and see if
hold on.
There.
To Mr. Once. Yeah, yes, sir. I definitely I'll send it again, but it.
Yeah, let me check. Let me check one place here where it might be.
Yeah, because that's sent on my end.
Okay, and it might just be a delay. With it as well.
Okay.
Sometimes those things take a minute. Sometimes they go to spam. I'll check. I
Yeah.
don't have an issue with that.
Okay.
I'll look into that.
Yeah.
And if I don't get it,
please.
If it's not showing up, I'll let you
know.
Please
let me know ASAP. And just to hash earlier, just like we talked about our positions earlier. I just wanted just let credit acceptors know that I'm really open to resolving this matter so we can move on.
Okay.
All right. Thank you.
No, I appreciate that. I'm email. Oh, here it is.
Yep.
Oh, it's really funny. I'm not getting a bunch of emails. That's a problem.
Wow.
Okay. I'm glad you pointed that out. I have an email from my colleague that really should have come in. So I'm gonna have to close this out and figure out what's going on.
Okay. All right. Thank you.
I'll take a look. I'm just gonna. By the way, I'm just gonna hit send on this email that I was writing to you.
Okay.
It may be moved by your email.
Okay.
But I'll just hit it since I already tracked it.
All right, perfect. Don't want to not send it. It's perfect. That's cool. I'll take a look at it regardless.
Sounds good, and I'll be back in touch with you soon.
All right. Thank you.
All right. Thanks so much.
All right.
Bye.
You want to know what that's called? That's called talking to a professional attorney. That's called negotiation with a professional attorney. That's called trying to reach a settlement and hashing out the deals with a professional attorney. That's called corporate-like negotiations. That's what that's called. The attorney for credit acceptance. Yeah. I'm sorry, you pro se sovereign citizens. You know, we know that, yeah, they will never even call you directly because they know all your documents are frivolous. All your documents are frivolous. All your affidavits of truth are frivolous. All your notices are frivolous. And they don't even respect you on a professional level to contact you, reach out to you, email you to start a dialogue on how you can resolve the lawsuit and the complaint. Not only am I working to resolve this matter, and we are working, I've been working closely with their attorney. So let's reach it. If we can resolve the issue, then I'm cool. Like I say, this wasn't personal with credit acceptance from the jump. It wasn't personal. Actually, they're not even a company that's on my hit list. I have a company that's actually on my hit list. I won't name their names publicly because I've been gathering evidence and intelligence on it for 2 years now. And I'll be ready to, and the thing about it is, well, I'm not even going to, I'm going to leave that there. But CAC wasn't even like, I didn't have no issue with them. I was current when I filed the lawsuit. I wasn't in default when I filed the lawsuit. I wasn't in the threat of repossession when I filed the lawsuit. It was never about non-payment. Nah. See, over here, we don't file lawsuits just because we're in default and they about to come take our stuff. We don't rest and try to file a lawsuit. I was already current. There was no issue on that end, but they were, casualties of war. They was right there in the line of the scope. I had to scalp them. And I wasn't even looking to get them, but it's like when you see like a lion in the wild, he kills a zebra, kills one of those male zebras, and then he sees like what's one of those animals that they always eat, like a water hog or water buffalo, one of them just trotting across. I'm like, oh shit, here's another opportunity. Let me get you too. That's all this was. That's all this was. This opportunity was there to get them. The opportunity was there because I was looking at someone else when I was researching on this other company. They popped up, and I said, "Oh, what a coincidence!" So while they popped up, I said, "Oh, well, let me get you too." That's all that was. But as you can see, I'm in active negotiations with their attorney. There's no middleman. There's no attorney that I'm using. I'm acting as my own attorney. And this is how negotiations happen when they start to respect you on a professional level. So with that being said, today we have shout out to Team Skeptics. Let me pull this up. Shout out to Team Skeptics. And when if you go back and replay the video for the past few minutes, you see me, I was talking to the attorney. It's not really so much about I'm talking to the attorney because we have a clear understanding. We brought up, hey, what resolution looked like. So we started, I started throwing some numbers out, throwing some things out there. He had his counter, I had my counter, talking. But we are both fully aware that, hey, even if we don't reach a settlement, that we all know, we said it each other. He said, hey, listen, at least we'll just have a friendly battle in the litigation. That's what he said. Like we're going to, if he got to go to war, he's coming with his best. I'm coming with my best. But guess what? I find him to be a pleasant guy. I actually like him. I find him to be very pleasant, very reasonable, very pleasant. Have no issues with the lawyer. Very cool. Come win, lose, or draw. Get mad, but send him a congratulations text if he wins. If I win that, he probably should send me one. Doesn't matter. But we got that bar understood. Hey, even if this ends up, we have to bite each other's heads off. Oh, we could do it. But this is one of the things about court. It's never personal. It's never, the minute you start to take this stuff personal, like they're trying to violate your rights, like they just woke up and just picked your name out of a hat and let's just violate this person's rights. With the finance companies, it's never like that. With the mortgage companies, it's never like that. With the credit card companies, auto companies, they are not specifically targeting you. The number one reason for these people to jump on your line is when you don't pay your debts. And if you want to bring up breach of contract, and this is from a legal standpoint, I'm not going to cite the statutes and the cases because I know gurus watch from the clouds. They go back and watch my videos after the live. They can't stand to listen to me live, but they'll all go back and watch my videos and lives when it's done. See if I drop the nugget for them to go regurgitate to their people. Absolutely not. But the thing about this situation is, if you are going to claim breach of contract, do you know from a court legal standpoint, the one that's claiming a breach of contract has to be the one that's continuing to honor the contract? You can't even go to court screaming breach of contract if you're in breach yourself by non-payment. You do realize just because they breach doesn't mean you stop. You still have to be in good standing. But we all know that the fraud only comes out when you are in default. So without further ado, and before we get there, let's see if I can do this. Let me just show y'all, because we got a fun video today. Actually, it's very informative. It's actually very informative. And by the way, just as expected, Anton Daniels is mostly potentially going to be filing a lawsuit against Corey Holcomb, as expected. One second. All right. Let's get here for a second. Let me do this. Let's play this back. How you doing? This is Mr. Thomas again.
Hey, Mr. Thomas.
Hey.
I was just emailing you.
Oh, okay. All right, perfect. I just wanted to make sure you that is the attorney for CAC. See, we're emailing, we're conversing back and forth. We're trying to reach an agreement. We got some procedural things that we have to get over. But this remember, I'm pro se. Notice that's me. I don't have a lawyer. But this goes to show that when you understand court, and you understand the legal procedures, legal proceedings, these attorneys will talk to you like you're on their level. The reason why they don't want to talk to you sovereign citizens, because y'all sending in these frivolous affidavits of truth, these stupid things that have nothing to do with the legal system. They don't understand it. They don't respect it. And it's the waste of time. This is why they just proceed to take you to court and take your stuff. Versus before we get to that stage, we're saying, how can we resolve this issue? Like, what are you actually looking for? What are you trying to do? Hey, this is what I'm trying to do. This is what how I think we can resolve it amicably. You received it, and if there was anything.
No, didn't get it. Did you send me a document?
Yes, I sent it to your email.
Oh.
7 to the email. Let me.
I'll open my spam filter and see if.
Yeah, yes, sir. I definitely is.
As well.
Okay.
Sometimes those things take a minute. Sometimes they go to spam. I'll check.
Yeah.
I'm having an issue with it.
Okay.
I'll look into that.
Yeah.
And if I don't get it.
Oh, please.
If it's not showing up, I'll let you
know. Please let me know ASAP. And just to hash earlier, just like we talked about our, positions earlier. I just wanted, just let credit acceptors know that I'm really open to resolving this matter so we can move on.
Okay.
All right. Thank you.
No, I appreciate that. I'm emailed. Oh, here it is.
Yep.
Oh, yeah, it's really funny. I'm not getting a bunch of emails. That's a problem.
Wow.
Okay. I'm glad you pointed that out. I have an email from my colleague that really should have come in. So I'm gonna have to close this out and figure out what's going on.
Okay. All right. Thank you.
I'll take a look. I'm just gonna. By the way, I'm just gonna hit send on this email that I was writing to you.
Okay.
It may be moved by your email.
Okay.
But I'll just hit it since I already tracked it.
All right, perfect. Don't want to not send it. It's perfect. That's cool. I'll take a look at it regardless.
Sounds good, and I'll be back in touch with you soon.
All right. Thank you.
All right. Thanks so much.
All right.
Bye-bye.
That is what you call negotiations, proper negotiations, knowing court rules, knowing the court procedures, negotiating directly with the other side's attorney, because they know you know the court rules, they know you know court, and they're respecting you as such. Now ask your sovereign citizen gurus, what can any one of them ever get one of the opposing attorneys on the phone where you're working together to resolve this issue, to get this case dismissed? Huh? Just all you got to do is just find one. Hey, I'll give you a list of sites to search. You could search I said Wells Fargo because they on the hit list too. That's what I was thinking about it. Instagram. You'll find out. I think you'll find it there. Facebook, or you're going to find a bunch of courts can't do this. The courts can't do that. They can't do this. Corporations. The Black's Law Dictionary says this. Can you find any of them that? Because you could just tell by my documents that it's legal, professional, sensical, coherent, following the court rules. Because they even got court rules that deals with communications in an ongoing litigation matter. Did you know that? They have court rules that even governs your private communications during the litigation stage. Okay? And ask any one of your gurus earlier. I mean, and I didn't record the conversation earlier. I was on the phone because I hate how the Apple... This call would be, I didn't want to spook them away from talking. I want to get them on the phone. But the question brought up, so what are you looking at? How do you think we can resolve this issue? That question was posed to me. Do you think that these social media gurus will ever get that question posed to them with their affidavits of truths and their silly, frivolous documents they send to these people? Absolutely not. I am your teacher's teacher.
You're rocking with the best.
No, I am your teacher's teacher. Whoever your teacher is, I'm his teacher. I'm her teacher. I am your teacher's teacher. Listen to me, you'll go to the promised land. let's get into it.
Do I have counsel for HAPO?
Yes, Your Honor.
Okay.
Right here.
Okay. Counsel, I'm prepared to go forward. Let me just make sure I got my notes in hand here real quick. If you just give me a second. Okay, I'm there. Thank you. Go ahead, counsel.
Yes, Your Honor. First, I just want to clarify, I'm not sure what Mrs. Spinda is referring to in terms of a trust. This is a lawsuit that has been initiated against Mrs. Spinda. Mrs. Spinda purchased the 2018 Audi A6 on January 29th, 2019. She executed a retail installment sale contract, and that contract was assigned to Hoppo Community Credit Union. Hoppo provided the financing contemporaneously with the purchase of the vehicle.
Question, because if you look right here, the order of the court is for them to take possession of the vehicle. Order that if deemed necessary, the sheriff is directed to break and enter a building or enclosure to obtain possession of the property if it is believed to be concealed in the building or enclosure, and whether or not defendants is present at said occurrence as provided for in the codes and the statutes. Now, most people say they can't do that. Their actions are governed by rules and statutes. But the question that I always have, why didn't she just have the trust pay for the vehicle from the beginning? Cash money. Yep, we all have a trust fund account, right? Why do you fill out installment contracts? Why do you fill out sign mortgage agreements and notes when the bank can just go tap into your trust, get the principal and interest all at one time? It's a whole lot easier for the banks to get their principal and interest all at once instead of spending money on foreclosure, spending money on lawyers to file these lawsuits against them, spending money for this and defending the case and fighting the case, or risking that the borrower won't repay, or risking this and that. Why? Because they lose money in repossessions and foreclosures. Why don't they just tap into your full account? Because banks, just like other finance companies, they're all about business. If they can get their money all the way up front, they won't have to. Why would they need to deal with you? And you know what cannot be the answer anymore? What cannot be the answer is, oh, they just, the greeds of the banks, they just want you to pay after they already got all, they just want you to pay all. No, that can't be the answer anymore, because it doesn't make economic sense when they lose money when they have to do these things.
If you just want to move forward, I'm sorry to interrupt you, counsel. If you just want to move forward, I'm prepared to go forward today. And I'll indicate to you, as I will indicate to Ms. Spinda, that you each have 5 minutes. You may proceed.
Thank you, Your Honor. Hoppo has to protect the security interest in the vehicle. We're here today, and Hoppo's requesting that you grant the order that was presented, proposed order that awarding possession.
Thank you, Ms. Spinda. You may address the court.
I just questioned, have I unknowingly entered into any type of contract speaking with anyone here today?
No. You're not in cross-examination. It's your time to spit your case, spit the facts, spit the legalities of your case. What's your legal defense? Why do you feel like you don't owe? Why do you feel like this lawsuit should be thrown out? What are your legal defenses? But let's see how she responds.
You've knowingly entered into multiple contracts with that credit union, and in an effort to try to defraud them, you took their money, used their money to purchase goods for yourself, and then refused to pay that money back.
That is the epitome of anyone who follows the sovereign citizen's belief. That's their mindset. Get the money up front, don't pay it back, and then file these claims of fraud when it's time to face the consequences of not paying your debts.
So they're just stealing their things back before you steal them for good.
Ms. Spinda, I'm not here to answer questions. I'm here to hear arguments regarding your position on a show cause for a replevin of a vehicle. So you may proceed. Go ahead.
Okay, this is the first time I've done this.
Sure.
So
It doesn't matter if it's your first time, you're representing yourself pro se. So you're expected to know the rules of courts and know what happens in proceedings and what you're supposed to do. And now is not the time to ask questions about a contract, a trust, or any of that. What's your legal arguments? Because I'm waiting.
Is this considered a civil or a criminal case?
There you go. You're asking another frivolous moot point. You know you're in the civil case. You know you're being sued. Get to the point. Why do all y'all ask these questions? It means nothing. Stop asking these stupid questions. It means nothing.
Again, I cannot answer any legal questions. You mean you're responding to the show cause?
Okay, just for the record that you're not answering that.
That has not, the judge has nothing to do with it. The judge has nothing to do with that. It means nothing.
Question. Thank you. And who is the alleged victim here?
Again, I'm not.
There you go. But I understand why she's asking those questions, y'all. This is that 1855, 1736 sovereign citizen mentality. There must be an injured party. This is a civil lawsuit. This has nothing to do with an injured party. As a matter of fact, the injured party is the people who you got the money from and didn't pay them back.
I'm not here to answer questions. I'm here to your response to the show cause. You may proceed.
For the record, you did not answer my question. Thank you. I am a free woman of flesh and blood. Minor, I ask for your.
Okay. Once again, y'all, what does that have to do with you not paying your debt? You being a free woman. Somebody just put it in the chat. Please tell me what's the connection, because I seem to keep missing the connection. I think it has nothing to do with anything. But if I'm wrong, put it in the chat. Let me know.
Your status here today.
Once again, I'm not here to answer any questions. You may proceed.
For the record, you did not want to answer my question. Okay.
I'm here to your response to the show cause. You may proceed.
For the record, you did not answer my question. Thank you. I am a free woman of flesh and blood. Minor, I ask for your status here today.
Once again, I'm not here to answer any questions. You may proceed.
For the record, you did not want to answer mine.
But the question is, why does the judge, what does the status have to do with the reason why Harpo is suing you? The judge is elected. He took an oath to the Constitution. These judges are elected. They are sworn in. This administrative judge stuff, it doesn't work. He's licensed to be on the bench. He has the authority of the powers granted to him by the Constitution of the United States and the state constitution. That kills any argument trying to challenge a judge's authority. The 10th Amendment allows them to make rules and laws that govern the welfare of each citizen of each state, and they're allowed to have courts situated throughout the United States inferior to the Supreme Court, meaning no other court can interpret a case differently from how the Supreme Court did. That's all it means, and none of them ever do it. So once again, those arguments are moot.
Question. Okay. My trust, when I say my trust, I'm talking about, I trusted Harpo.
So when you're talking about your trust, you mean you trust the Harpo. This is the semantics games that sovereign citizens get hung up on. Semantics, what does that mean?
With my trust, a promise that they would provide proof of consideration for the vehicle. I don't have just this issue going on with Harpo. I have also an investigation going on with my home, and the FBI has been contacted, and there's been a claim that has started an investigation on Harpo.
You know what's going to happen with that FBI claim, y'all? Nothing.
Fraud. It's fraud against my estate, against my trust, against this birth certificate, Kathy Jean Spinda, and
sovereign citizens, your estate, your trust, your birth certificate, none of that has, number one, it's not real, and number two, has nothing to do with you not paying. See, you notice that they never want to answer the question of why they're really in court. You're in court because you didn't pay your debt. That's why you're in court. That's the only reason why they're there for. All that other stuff does not matter. And what does your birth certificate have to do with this? If you are thinking that there is an account connected to your birth certificate or your social security account that you can draw on to pay debts or whatever you want to do, you have been misled. You have been lied to. It's a myth. Every single account that's on the books at the Treasury is available to public inspection. So if you have a secret account, show me the secret account in which you have rights to draft instruments and draw checks on. And if it's legitimate, why doesn't the Treasury ever send any money from these checks that y'all draw on them? Why do they not go anywhere? Or why do they get reversed? Or why does the IRS ask for the check back? Like none of these things are real. And just because you don't like that I'm saying it doesn't make it any less true. Because if you don't want to listen to me, I'm gonna let the judge tell you.
I have a truth affidavit of truth here that I would like, if you would, someone could give this to the judge. That was served on June 12th I have an affidavit of truth and a proof of claim that
right out the Sovereign Citizen Redemption Manual book. That's at the back of the book. Like none of that matters. They have no legal authority, no legal obligation to respond to your affidavits of truth under the UCC. And it does not stand as true just because they don't respond. You notice how the lawyer is responding to my documents, sending me emails. We conversing back and forth with my documents. But you notice how all these affidavits of truth and these proof of claims actually go unanswered because they have no legal obligation to answer your affidavits of truth. And just because they don't respond within 10 days does not mean it stands as true. Y'all keep listening to the maxims at law. Keep thinking of maxims. You keep trying to quote the maxims. All right now.
Had properly served to Capital Community Credit Union and Chris Torres, who is the Vice President of Asset Recovery. And I have given her this proof of claim truth affidavit on June 14th in a meeting that we had for me to look over the wet signatures of my contract. So she has this in possession. This has been legally served to her, and I am not done with this investigation, but there is fraud going on with my case.
Yeah, no shit. Because you're the one that's committing fraud. When you went to the credit union to get that loan, you intentionally deceived them to secure those goods. And misrepresenting your intentions or providing false information are both acts of deceit and key elements of fraud.
And Samuel has proceeded to move forward on this lawsuit against this.
Against what? Against what? Against what? Oh, let me guess. Against the All Caps Corporation and not you. I get it.
And I tried to explain to him verbally on the phone the fraud, but all he said is, I don't believe you. He told me he didn't believe me. I tried to explain to him on the phone. He just said he didn't believe to me. He's protecting his pocket and he's protecting, of course, his client. But I have in my possession fraud from HAPO. And he has ordered, or he wants an order for the Benton County Sheriff to break and enter into my home to steal my car, where the proof of consideration is not, it's not legitimate. It's a copy of a copy of a copy. From a bank, at least I should get a bank certified copy, get originals, but I have proof here. I have proof that HAPO is committing fraud. Now it's to do with another case. It has to do with my house. The actual proof that I have is on my home. So I have not shared that with Samuel. I have, however, emailed it to Chris Torres, the Vice President of Asset Recovery. She received all of it with detailed notes on the fraud itself. I showed her the fraud itself. This is not a game. I'm not just trying to shirk my responsibilities. I come here with clean hands, and I'm telling you the truth. I don't want the Benton County Sheriff to break and enter into my home when where's the injured party? There is.
Okay, so the problem is the fraud. Okay, let's just say there's fraud, right? Let's just give her that. That still doesn't invalidate your obligation to pay under the contract. If you have fraud, then you need to file a counterclaim. But you can't bring up. Let me ask you this: why do people always want to see the wet ink signature after they being sued? Why don't they ever ask for it at the beginning when they're filling out the contract? Matter of fact, why do these people always go to these finance companies? Won't you go straight to your estate and your trust and get what you need so you can buy the property outright? Why are you going through them? Won't you go to your trust and get it? Go to your trust. Go through your trust. It's sitting there waiting for you. It's waiting for you. Go through your trust. Let me guess. It's a secret. Well, if it's a secret, then how do you know it then? If it's such a big secret, how do you know? Oh, right.
There's no injured party here for them to force themselves into my home.
But it ain't really your car now, is it? I mean, you were still in possession of it when this hearing occurred, but legally speaking, it's the credit union's car and you're keeping it from them. So they have every right to ask the sheriff to go on your property and retrieve it.
When there's fraud going on, and as I said, as serious as I am, I've also started a claim against Samuel Myler in federal court. And I have the case number for that as well, because he's trying to harm me and harm my family. When there's fraud going on, if he won't back up, he's protecting his pocketbook. Now I'm looking at you in the eye and I'm telling you the truth. Okay, like I said, I have clean hands. I have the evidence. He asked me for it, and I told him to go ask Chris Torres. Chris Torres has all the evidence of the fraud. They know about it. They've got 21 days per maximum law to give me very specific information. And I think once you look at this, the questions I'm asking, you'll see how serious this is. So I'm asking that I'm motioning that this case be dismissed so that the investigation can continue on.
Okay, thank you. I appreciate your comment. Brief response.
Yes, Your Honor. With all due respect to Mrs. Spinda, I only represent Papo with regard to the vehicle and the debt associated with the vehicle. I don't represent Papo with regard to her home and whatever's going on there. So I don't really have anything to say about that, and that's not at issue here today. Frankly, Your Honor, I think that there are a lot of things that Mrs. Spinda has claimed or raised that I can rebut or dispute, but none of it is really relevant to why we're here, and none of it is really before the court. So I would just ask that the court consider the application for replevin and grant the order that has been presented.
Thank you. Court is here today on the motion for replevin.
And basically what they're saying, y'all, is they brought the lawsuit, right? And they brought the lawsuit for not payment, and they want to take possession of the vehicle. Cool. Her rebuttals has nothing to do with a legal response to their complaint. It's all fraud, and this is happening and this happening. But the reason why they're really there is because she didn't pay. And one thing that you'll notice about these people, they never want to get into they never want to stick to the subject at hand. Just because the banks did not provide you funding according to their beliefs, it does not mean your contract is not valid. It's binding and enforceable. Somebody put the money up. The money didn't come from the Federal Reserve. Federal Reserves do not engage in active consumer lending. The Federal Reserves, they set the monetary policy, they set the interest rates, and they deal with the short-term lending of banks as a last resort. That means if you can't find sources of financing anywhere else, you can go to the Federal Reserve, and then you have to pledge sufficient collateral. And that's for the financial institutions to carry on their operations. It's not to grant you a loan. And Title 12 USC Section 412 is one of the most misinterpreted statutes. It has nothing to do with consumer lending.
And replevin is a special statutory proceeding to determine title to or right to possession of personal property. The prima facie element of a replevin claims are as follows: 1, ownership of the property; 2, the right to its possession; 3, a demand on the defendant for the surrender; 4, defendant's refusal to surrender the property; and 5, defendant's consequently wrongful detain of the property. The court did consider the arguments specifically by Ms. Spinda that was filed as a affidavit of truth that set forth her arguments with respect to the, I'm assuming it's an answer.
There you go. I'm assuming it's an answer. They don't know what it is. Okay, so they filed the replevin to establish the rights and titles of whether they have possession of the property. So they filed a motion, right? What she was supposed to do was respond to the replevin in a motion or a pleading, not an affidavit of truth. An affidavit of truth is not a legal answer. Remember when I said we respond with motions and pleadings governed by the court rules, and they respond with notices and affidavits of truth? That has nothing to do with the court rules of procedure. You see the difference?
With respect to the motion for replevin, based on the evidence presented, arguments of the parties, and the affidavit of truth. The court will find that the plaintiff has proved by the preponderance of the evidence, more likely than not, that a repellent should be issued. Therefore, the court is awarding possession of the property of two. Please do not interrupt me. I'm going to find.
There you go. Right. So she responded with an affidavit of truth instead of having a legal reason why the repellent should be granted. They filed the repellent because she didn't pay. So her response is there's fraud going on. They didn't give me proof of consideration. Well, why didn't you ask for the proof of consideration when you first got the vehicle? I guarantee you she was not thinking about no consideration or fraud when she first got the vehicle. I guarantee you that all this fraud and proof of consideration only comes out when they're getting sued for non-payment.
Find you in contempt, please.
We'd like to
2018. I'm going to sign the order, Miss Splenda. I'm going to find you in contempt if you interrupt me again, and I don't want to do that. I don't want to do that. I'm signing the order, and you may appeal my decision, but I've signed the order. I'm asking the bailiff to escort the defendant out before I find her in contempt, and I don't want to do that. That concludes the matter on this matter. Thank you so much. Please exit my courtroom.
All right, so that's the end of the first hearing. And if rumors are correct, then Cataspinda is still traveling home by foot. So now on to our second portion, which is her eviction hearing. And in my last video, I stated that according to Washington law, a new owner must wait 20 days after the foreclosure sale before filing for a writ of eviction from the court. Well, her 20 days are up and she ain't leaving. So this is that hearing.
Y'all subscribe to Team Skeptics. I like Team Skeptics.
I did have an opportunity to review all of the submissions in this matter, including Ms. Spenda's answer. So I will defer to you, Ms. Spenda. Thank you, Your Honor. And for the record, my client is present on the stage under the name Jerry Fielding. This matter is on today for a show cause hearing. This property was subject to a trustee sale with plaintiff purchasing the property and obtaining the deed on April 8th, and this property is located here in Benton County. So venue and jurisdiction are appropriate. The defendant was provided notice pursuant to RCW 61-24060, indicating the plaintiff was now the purchaser of said property, and that 20 days following the trustee sale, the plaintiff is entitled to possession. The defendant has failed to vacate the property. A unlawful detainer action was started by former counsel, and that was personally served upon the defendant on April 20th, 2024. Plaintiff has set this matter for a show cause hearing, and proper notice was provided to the defendant pursuant to the proof of service on record. The defendant has filed an answer to the unlawful detainer, as well as an answer to the show cause with a counterclaim attached to it. And RCW 5912 dictates that these are summary proceedings. The case law dictates that counterclaims cannot be considered. This court lacks subject matter jurisdiction to consider claims that are not related to the actual possession of his home.
Well, this is awkward. In almost every sovereign citizen court case I cover, they swear up and down that the court doesn't have subject matter jurisdiction. But the one time that I cover one of them filing a counterclaim, the court actually lacks subject matter jurisdiction.
And the reason why the court lacks subject matter jurisdiction, because I guarantee you everything she filed had nothing to do with the subject at hand. I guarantee you it was more fraud allegations. It was more, I'm the living woman. This is the corporation. I guarantee you had nothing to do with this matter at hand. The courts only have subject matter jurisdictions if they have jurisdiction over the claims that you file. And as a matter of law or equity, they are authorized by law or in equity to grant you the relief. If you are filing these astronomical claims with these astronomical dollar amounts and the law or the principles of equity doesn't even grant them the authority to grant you the relief that you requested, they're going to lack subject matter jurisdiction. So even your claims in your claims for relief has to fall under rules and procedure and court precedents. They can't just grant you whatever you want just because you want it. They're even governed by their own set of rules.
We would ask that not be considered today. The defendant has filed this counterclaim, not in this matter, but as a new civil case. So moving forward today is not prejudicial from having this transferred by a civil judicial officer outside of the summary proceedings today. So we will have those claims forward on a different docket. We are here today because my client has yet to gain possession of this property since purchasing it. He is losing money every single day that the defendant remains in the property. We We have substantial attorney's fees here in the amount of $2,005.83. We have costs in the amount of $419.85. These damages were incurred prior to receiving a very lengthy response from the defendant, and the longer this matter goes, the more costs are incurred for my client. We're asking the court today to enter a writ of restitution with judgment, findings and judgment language, and also my client is reserving on any physical damage that may be caused in retaliation for this action to pursue that at a future date. All right, thank you. Mrs. Spinda.
Yes, I am Kat Spinda. This is my land that I have a allodial title on. The defendant, Jared, he had not rebutted my affidavit.
Right there. Right there. First of all, the allodial title. She says she has a allodial title, but don't get confused. She thinks she has a allodial title because she says she has a allodial title. She doesn't have a allodial title because it was awarded in a court proceeding or a judge signed the order or the title over to her. No, she got it because she believes she has it. She thought that instead of filing a response to their complaint, she once again filed another affidavit of truth, just like she did in the last case. And this is the part where it really becomes scary, because with them, they don't ever sit back and say, you know what? If I keep getting denied in every courtroom I step in, is there a chance that maybe I'm doing something wrong? Does it always have to be a conspiracy? Does it always have to be they don't want you to enforce your rights? Is there any remote possibility that maybe they're just wrong and they're misinterpreting the law? Is that ever going to pop up as a possibility, or it's going to be one big conspiracy, one big fraud, and they just have it personally out for them to make their lives a living hell? Like they just pick their name out of a hat and say, how can we make these people's lives hell every day?
I had sent him a notice of liability, and at this time I choose to remain silent other than the challenging of the jurisdiction, which I requested. We cannot presume or assume jurisdiction. It must be proven in writing. And so therefore I'm asking for that today. Although I've been railroaded in this system.
There you go. And y'all, once again, you know what that means? I'm doing all my filings and it's not working. Told you, when their filings get dismissed or denied, it's a railroad. It's a travesty. It's a conspiracy. It's never, damn, it's denied because maybe my motions and pleadings are not in line with court rules and I haven't cited legal authority to support my claim, just like any other normal lawyer would do.
And there has been no justice in the system from the very beginning, and everything that I have put forward has been completely ignored. And so
because it's frivolous. That's why. Because it's frivolous and nonsensical. That's why. That's the only reason why.
So I just wanted to put all of that on there for the record. The counterclaim is to protect myself, my family, and my animals from harm because of trespass and fraud.
Geez, I didn't think you'd ever shut up, Karen. And if you truly want to protect yourself, your family, and your pets from the harms of trespass and fraud, then maybe you should stop trespassing in that man's house and stop committing fraud. Now, you want to try that right to remain silent thing again?
I choose at this point to remain silent, and except for the fact that jurisdiction needs to be proved. I am a living woman. I'm not a corporation that they are going after.
Duh. They're not going after, they're going after you. Just because the court title, your name's in all caps, the semantics game, it means nothing. It's you, the individual, you, the one who signed the contract, the one who signed the mortgage, the one that you. It's not no corporation, it's not no legal fiction, it's you. You're sitting in court, aren't you? You're not there as a third party because they're bringing in the trust and they want you to stand as surety under the trust. It's none of that. It's the person who signed the mortgage, who signed the note and did not pay. Let's just cut it out. Let's just cut it out. The people that bringing in the court are the people who got into these agreements, got into these contracts, and did not pay, and therefore otherwise defaulted on their contracts. Those are the people they're bringing in court. Not no trust, not no 60KV trust, not no birth certificate, not no straw man, not no all caps, not no corporation, not no estate, None of that. The person who's not paying their bills.
And Oxef Investments is a corporation. Only a corporation can go after a corporation. And I'm a living woman. And so therefore the counterclaim is actually against Jared Fielding directly for harming me and my family and moving forward, even though he was provided all the proof and evidence beforehand, but he just ignored it. So I'm hoping today that I will not be ignored and that I motion that this case be dismissed without prejudice and allow my counterclaim to go through to prove the fraud so that we are not kicked out of our home.
But you know, one thing that she would never, she sidestepped throughout this whole process. Why did you stop paying? Like, we all know what happens when we stop paying our bills. We know what happens, unless you could prove from a legal standpoint that you legally are entitled not to pay. But put that to the side because none of them ever can. Why would you like let me ask you a question. Does your finance company just wakes up one morning, just repossess your vehicle just out of the clear blue sky? Did the sheriff just comes, knocks on your door and just puts you out of your house for no reason while you're paying your mortgage on time? If that has ever happened to you, I will take your case for free. I swear to God, I will take your case for free. I will do the paralegal work. I'll pass it over to my attorney friend and say, y'all, we got a smoker. There'll be so many rights, laws that they violate. They'll have to settle for a high number. I will take, if that's been your case, send me an email at the bottom. I swear to God, I will take your case for free.
Because there is fraud. And so I leave it to you.
Damn, Karen, you remained silent twice as long the second time around. Now, I guess it's about time that we hear the judge's decision.
I do, as an initial matter, find that the court does have jurisdiction over this matter. It has to do with direct possession of property located in Benton County, Washington. I also find that as it currently sits legally, is the plaintiff that has legal right to possession of the property. So
I would like to get jurisdiction in writing. You cannot presume it. I must be able to get that in writing. And I provided all the case law to prove that.
You've made your record. Thank you. And you do have the ability to request appeal or revision of my decision.
Well, shit, no car, no home, and less than no brain cells to get herself out of this mess. So after the hearing was over, she decided to add her commentary on why it's not her fault that she's now homeless.
So now that you've seen this and you saw that she ignored everything, and let me tell you, I put in all of my proof, exhibits A through P, my counterclaim. The counterclaim shouldn't matter. It shouldn't matter. There's fraud going on. It shouldn't matter if they're stealing from the people, if there's crimes against humanity, Megan.
I'm not going to let you sit here and gaslight these people. Stop it. It's not fraud. When you use the word fraud, you are subject to a heightened pleading standard. It's in every court rules across the United States, state or federal. The who, what, when, where, how. Who fraud you? What was the fraud? When did the fraud take place? Where did the fraud take place? And how did the fraud cause you damage? If you come with any sovereign citizen rhetoric, it's going to get dismissed for failure to state a claim. When you use the word fraud, you are subjecting yourself to the extremely high pleading standard. Don't say fraud unless you can prove the who, what, when, where, how. If you can't prove the who, what, when, where, how, your complaint is going to be dismissed under Rule 12b-6 for failure to state a claim upon which relief can be granted. There's no ifs, ands, or buts about it.
You don't care. You know, sometimes I think I'm just too nice. I'm trying to be nice here. Okay. I'm trying to talk to people on a level that they would understand. But, you know, these black robes, they don't work for us. And I bet you Megan doesn't even have an oath of office, just like Joseph Burrows does.
What does that all mean? Somebody put in the comments. What is that supposed to mean? What is the oath of all? What is that supposed to mean? Because it never seems to scare any of the judges. Like, what is it supposed to mean?
Doesn't have an oath of office, but we're going to do a request anyway. We're going to start really digging into these people who keep abetting in fraud. So we can add now Megan to the list of abetting in fraud. So that's the way I look at it. They all protect the banks and the corporations. Folks, this is an emergency. And so if you're wondering or thinking what's going on, What's going to happen to Kat and her family and her animals?
Nobody important is thinking that, Karen.
Well, the way it looks right now, they're just moving right along, and they don't care whether there's fraud or not.
But you notice how she never said, what's the fraud? What is the fraud? Explain the fraud. Stop just using the word fraud. But do you want to know what it boils down to? She never cared about fraud when she first got the vehicle, when she first got the home, when she was making the payments. Why didn't she uncover the fraud while she was current? It's a coincidence in the timing of all these claims. You know, the timing is always interesting to me. You never ever hear anything about fraud when they're current. You notice that, right? Well, it's like they don't even care about the fraud when they're current. I'm trying to figure out, why don't you bring up the fraud while you're current? Why don't you bring up these claims while you're current? Why don't bring up the claims? Because they don't know how to put it legally together, a legal sufficient claim together, and which is all the reason why you need to join the Supreme Elite Team University.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline, credit acceptance on a resume, with stories in the fine lines.
Fact, they know because I've already showed it to them, and she said she read through all of it, so she saw all of my proof, the proof that the banks provided nothing, that I was frauded. I provided all of it, just like I've showed all of you. But see, the truth doesn't matter in court. As we continue to march in the truth, this is what I want to share with you. The truth wins no matter what.
Oh, really? The truth always wins, does it? Well, the credit union won twice in this video. So what does that tell you about the taste of your sovereign citizen word salad?
No matter what happens, no matter what they do or what they think they're going to do, and driving around in their helicopters and everything, driving by, all the NPCs are closing in, but I'm not going to be afraid. I'm not going to sweat or worry, shed one tear. Ask me if I shed a tear. Nope, no tears. This is serious. This is very serious. What's happening in the courtrooms with me, with Trump, and all of the people that I know that are getting their cars stolen from, their children stolen from, their homes, their boats stolen from. We're going to have to start looking at some of this from maybe a different angle. And we now call upon the military to do their job and to...
Girl, stop. The military is not going to come to help you assist in your frivolous claims. What's the sad part about this is these people, like, they can never ever see the writings on the wall. No, I'm not even trying to be funny. Like, I feel so sorry for their kids. These people listen, these spaces have done more to destroy the lives of people than it's ever did to help. I've seen people time and time again lose their homes, lose their vehicles. I knew a guy that lost his marriage because his wife begged him just to pay the mortgage. And he kept filing these frivolous claims to the point where he lost his home, tried to file bankruptcy. Bankruptcy was dismissed in like a week, and she divorced him behind it. They was married for 12 years. And he's in a one-bedroom apartment now, still 5 years later trying to get his house back. Thinking that if he get his house back, he get his family back. Like it just warps your belief in your reality to the point where you become so detached from the normal rules and regulations and how things go that like these people don't even function like normal citizens. It's like these people are like aliens, and everybody who's associated with them goes down. This is a very dangerous space. That sovereign citizen mindset, you are not only a danger to yourself, you are a danger to those around you. It's a very scary thing. These people are losing everything behind these ideologies.
To step in.
As someone who has previously served in the military, I think I can speak for servicemen, both past and present, when I say we will be taking a hard pass on overthrowing the government just so you can steal his house, Karen.
Because I have proven, and you can clearly see, that they do not work for us, that they're going to adjudicate against the people no matter what. It does not matter what.
That's not true. That's not true. I have clients. That's not true. That's not true. That is not true. Maybe because I didn't put forth frivolous claims like you. Maybe I followed the court rules. Maybe I followed the rules of procedure. Maybe I cited authoritative court precedents to substantiate our claims. Maybe we did things the right way. Maybe it's you. Maybe you're the problem. Instead of gaslighting, the problem's everywhere else but the person that's in front of the camera right now. That's the problem, y'all. Y'all looking at the problem. Y'all looking at the problem right there. That's the problem.
The truth is. So let me know what you think. Put your thoughts in the comments below. Let me know what you think about Ms. Whitmire and her ruling, even though I have a low deal title, even though I am the owner or superior title holder of my land.
But your title has not been signed off by a judge, so it's not legally enforceable or recognized. That's the problem. See, that's the problem. With us normal people, we have title when we legally acquire it. With them, they have title when they believe they have title.
And it will be my land forevermore until I pass it on to my family, or when I decide to transfer it to somebody else, because we can't own land. God is the one who created it, and he made it for us so that we could have wonderful, prosperous lives.
Translation, I can just acquire whatever I want and don't have to pay for it. I can do whatever I want and not have to be accountable for it. One of the scariest things about these sovereign citizens is the lack of accountability. It's always everyone else's fault. Even though you are responsible for what you do, all our actions has consequences, whether good or bad. These people don't want to stand on nothing that they do, because as soon as they got to face the consequences, they're so quick to scream fraud or the system's out to get me or this. They don't ever want to stand on anything that they send in, lick their wounds and bounce back. They always are going to double down and triple down on the same frivolous claims that's gotten thrown out in multiple cases. Do you think they're going to change up and be like, you know what? Let me look at this from another angle. Something's not clicking. Nope, not these people.
Enriching lives, but they're trying to steal it all away. And you can tell by all of the taxes, everything going up, you're seeing more police on the street. They're getting more narky. You're even seeing the malls now with mall cops. Way more mall cops now than ever before. So it's even the toys at the mall that I is here, the Columbia Center Mall. All the toys, it used to be like a horse and a buggy and an elephant. Now it's a cop car and a helicopter and it's all of these response unit type of vehicles.
What did you use to pay when you go to the mall? What do you use to pay? Better yet, anybody that's listening that's a sovereign citizen, ask yourself this question. Would you accept the same negotiable instruments that you try to tender in to pay your bills? Let me ask you this. Would you accept, let's say someone owes you $5,000 and they say they're going to pay you in a money order. They go get a $1 money order. They cross out the $1 and then they write $5,000 on it. Are you going to accept that money order for payment? Are you going to accept it? And that's the problem with these people. They know they would never accept the methods of payments that they employ themselves to pay their debts. They know if they was the creditor, they know they wouldn't accept it. And this is that disingenuous spirit and that knowing the reality is this, but adopting an alternative reality just because of their circumstances. That is the most craziest part. I just can never wrap my brains around that.
Well, it's the programming. See, it went from this to that, and here we go. So anyways, I'm going to ask everyone here, if you have been following me, I really at this time need your support.
There you go. I knew it. I knew it was coming. Butter them up for the sympathy and then milk money out of them. Not the fact that you're doing everything wrong, not the fact that you're filing frivolous stuff, but since they're railroading me, I need your help. I knew the punchline was coming. There we go. Now we cooking with Crisco. That is why she's on camera doing what she's doing. give the sympathy story, and then ask for money.
And it doesn't matter how that support is, whether it's financial support, because I've been doing this for 3 years, pretty much on my own dime. I would really appreciate that.
And all the proceeds from those donations will be going to get Karen a new furniture set that feng shui's nicely with her new dumpster home.
This is going to come to a head because I'm exposing it. I don't know too many other people exposing it the way I am, as far as showing you everything that's
right.
Any other people exposing it the way I am, as far as showing you.
Oh, sorry. Let's get to the second one. Right. Of course. I told y'all. Now let's get to the other one. Now this right here. This is, let me share the screen. This is what you don't want to do. This is what you never want to do. And this is why I noticed why there's a lot of online sovereign citizens, like a lot of they do it online because they never want to stand on it in real life in public, because when they stand on it in real life in public, they don't want to look foolish in public. So they'll be online, they'll be on Facebook posts, Facebook groups, they'll be online, but they're never really putting in real work in real life. Very few of them really are doing it in real life, unless you go to Oregon or Washington State, where this movement is,
Hey guys, and welcome to today's video. Today, we have the return of my favorite sovereign citizen Karen of all time, Lenka Kaloma, more commonly known in anthropological and cryptid societies as Lady Bigfoot. Now, Lenka is a low IQ anon who has personally set the gene pool back about 2 million years. And in today's video, she's at a foreclosure sale because one of her dumbass sovereign citizen friends decided that banks and the money that they lend to buy homes were all fraudulent. So she didn't have to pay her mortgage anymore. Well, the bank disagreed, foreclosed on her home, and is now auctioning it publicly. Now, most of you already know who Lenka is, but not many of you will know who Kat Espinda is. So let me introduce you to the newest member of the hobo race.
What you know, you can't explain, but you feel it.
If you don't get this fake matrix crap out of here. Oh yeah, that's what they do. They think that since there's no real money, that there's no money to pay their mortgage, and since the banks didn't loan money, they don't have to pay their mortgage. I know, but that's why they stopped paying their mortgages, because of that right there. Oh my God.
You felt it your entire life, that there's something wrong with the world. You don't know what it is, but it's there, like a splinter in your mind driving you mad. The Matrix is everywhere.
Yeah, she's not crazy at all. So let's begin.
We're headed up here to the Benton County Justice Center courts with the whole crew.
Yeah, good morning. I have a quick question. So there's supposed to be a sheriff's sale. Would that be?
That's going to be outside. Outside a little.
Oh, outside?
Yep.
Okay, and okay.
Yeah, it's just going to be out in that area. Yep, just right outside. See where that man is standing. It's going to happen around that area.
Okay, and so who's going to be coming out to perform that?
I'm not positive. I believe the option here is sure we get there. The option here. So you know what's on the option here? What's that?
Oh God, I can already see how this is going to turn out.
They're going to be right outside here.
Oh, okay. Oh, do not enter. Do not exit.
Yeah, they got the whole sovereign citizen mob out there with them. Look at him. Look at him. Look at the sovereign citizen mob. Look at him. Look over there. There, they got the whole mob.
You think that's the guy right there with the notepad?
At least they standing on it. At least I give them that. At least they standing on it.
Well, yeah, just here for the, I guess, the sheriff's sale. I guess you have some.
I'm not doing sheriff's sale. I'm not a sheriff.
Okay.
So how can I help you?
Well, we were directed to this location. It's our first time we are experiencing this. So.
And who are you?
I'm actually attorney in fact for one.
There you go, right there. Keyword, buzzword, sovereign citizen, attorney in fact. There you go.
One of the victims. So yeah, one of the people.
Lenka, who claims to be an attorney in fact, is in fact not an attorney. In fact, she often portrays herself as an officer of the court or an agent of the government, to the point that actual government agencies like the FBI Little Rock Twitter page and the actual Department of Justice.gov page were having to warn people about Lenka's fake government agency. the Freedom to Breathe Agency.
Can you be a little bit more specific?
Yeah, so we have actually an issue here that supposedly there's supposed to be a sale of a property, which is owned by allodial title by a woman, and supposedly
And
an
who
parcel.
is the lady?
Cat Spinda.
Now, I'm going to be honest with you. If you didn't know her and she walked up on you, she could pass off as an attorney. She has the look. She has the dress that she could actually pass off as an attorney in court.
And do you have any kind of injunction or anything that?
I can show you all the documents here.
A junction, meaning signed off by a judge that you give to him that takes the property off the sale list. Not your stupid affidavits of truth, not your stupid own created defaults because they didn't respond to your frivolous claims. Not that. We're looking for a legal binding injunction signed by a judge, not your self-created documents.
Oh, but because you said that you are just the auctioneer.
I'm a process server.
Okay.
Papers, and
I see.
One of the things that we get roped to doing is to read these auctions.
Okay, so just first of all, this is the power of attorney of Cat Spinda.
Okay.
And here.
So can we have a conversation without all the cameras? because if you've got an actual document here, we need to make some phone calls and we have to.
Yeah, okay, yeah.
There you go. If you got an actual document, we need to make some phone calls. Let's just see if she's going to pull out in a stack of papers an actual legal document which they can get on the phone and verify with the clerk of court. Let's just see. I highly doubt it, but let's just see.
I can absolutely.
You're an attorney, right?
Well, we gotta make sure it's all documented. We gotta make sure it's all documented.
Yeah, we have to have it documented. But if you are speaking the truth, I'm speaking the truth, so there shouldn't be any problem, right?
Messenger service, so yeah.
There you go, right there. Real attorneys don't talk like that. But let's go.
I'm trying to do is figure this out.
Yeah, we will.
15 cameras on us here, so.
It's okay, nothing wrong with that.
No, I think there's a lot wrong with
You're in
that.
the public,
Why
sir.
would there be a problem?
Well, because I think we can handle this without drawing everybody into a YouTube video. Okay. So,
So
you're a
here
power
I can-
attorney, so this
yes.
means nothing.
Okay, fine.
There you go. You're a power of attorney, so this means nothing. Told you.
Love how she hands him her totally serious power of attorney, as if that's the undeniable proof that all of this is illegitimate. And normally you would expect Lenka to go into some pseudo-legal nuances. Instead, she just says, okay, fine.
How about some kind of
Yes, I will
judgment
give
or some
you.
kind of
May
document?
I just put it down? Sorry. Okay, here. Yeah, so here is our code of record. So I will present to you the documents here. So first of all,
And you're the attorney, so please explain it to
I
me.
am not a bar attorney, just for the record. I am a private counsel. Okay. I am not a member of the private bar association. Okay.
She's a private, just a bunch of words thrown together like they belong on a legal document. Basically, she's just a friend trying to help someone. Let's just take all these fake titles off. She has no power, no authority whatsoever.
But I showed you I have the power of attorney. It's for Cat Spinda's safety today. Okay. I'm just speaking on her behalf. So here's the deed of trust, which is clearly stating the parcel number. Okay.
Where is anything that can stop this sale?
Okay. Yes.
Hey,
Okay.
So I'm surrounded by about 15 cameras here. We've got somebody
Well,
who's
we are
calling
in
himself an
public.
attorney
We are.
who is
We
not
are.
an attorney.
We are in public. We are in
So
public.
we have.
I'm a
I'm
private
on the phone.
counsel.
Give me a
Yes.
second. Okay.
Oh, okay.
So.
I gotta be nice.
Yeah, well, what I need right now is a document that can stop this sale. And that's what we're looking for. This
Okay.
woman has to, says she, that will
Okay,
stop
so-
the sale. Some kind of injunction, something that says that we cannot do this.
They don't have it because you can only get those by order of the court, and none of their frivolous documents are ever going to survive any type of motion to dismiss anyway. So let's just watch the shit show.
So first of all,
I'm talking to you and somebody else.
There's $1 million lien on the property and a allodial title, sir.
yeah. So she.
Who are you,
she
sir?
holds-
My
she
name is
holds-
Richard David Potsner.
Well, Richard David Potsmer, shut the hell up. You can put a fraudulent $1 million lien on the house. You can petition all the crayon crunchers of America for your allodial title. It still ain't going to stop your friend from losing her house because she chose to stop paying her mortgage.
Okay, and who are you, David? Are you an attorney?
No,
See,
they're
I would
just-
love to have anybody that has
Okay.
legal authority to tell me that we can stop
Okay,
the
here,
sale so we
here.
can do that.
So Here you have affidavit of default and final judgment, okay? And this was served to Michelle Bertoli.
Affidavit of default. You know what that means? They sent their frivolous legal documents to these people. They shredded it. And since sovereign citizens believe that if you don't respond to their frivolous, nonsensical documents, which is incomprehensible, that you've defaulted. They call that a default on the private side.
The acting as attorney for the bank. Okay, so that's a copy you can have right here.
Okay, so that's an affidavit of default.
Yes, it's basically stating that the bank, first of all, did not loan any money, anything of substance to Ms. Spinda. Okay, and then it's also showing and proving that she actually owns the land, that they have no interest to the land. The only interest they have is to the APN number, which if you proceed to be selling that today, you are selling a fiction. And this is what this affidavit is about. Okay, there is also notice of liability. This is filed with the Secretary of State for.
No. Was it filed with the court? Want to know why was it filed with the court? Because it's frivolous, nonsensical.
State of Washington. Okay.
Is any of this filed with the court? Any of this filed with the court?
I believe Kat actually brought it to the district court. It's been dismissed, but this is a matter of public record.
Oh, so she brought it to the district court and it was dismissed, meaning there's nothing legal or binding that's going to stop the sale of the home.
Okay. It doesn't make any difference if I don't.
No, it does. It does.
Authority to do this.
Well, like I said, if you proceed, you will be selling a fiction. You'll be selling a parcel number where Ms. Spinda actually holds the title to the actual land through this land patent. Okay, it's a certified copy.
Right.
I have the original copy on my file, so you can have this copy.
I don't want it.
Well, okay. This is why we need to. This is why we need to have it on public record.
There you go. I don't want it. You want to know why? Because it has just as much value as a used piece of toilet paper. It means nothing. And this is the problem with these sovereign citizens. They'll spend hours, days, weeks, months putting these documents together. And as soon as they hit the print page, it still has the same amount of value as it did before they started typing on it. It might as well be a blank sheet of paper. Nothing changed with the legal validity. Nothing.
No, we need it all on public record so that we can warn the other gullible idiots of this country that following scammers like you, Takeaway X, and all the other domestic terrorists on social media will only lead to more debt and actual loss of assets like houses and cars. So if you're watching this video and you're thinking about changing your status from out to sea to back on the land or whatever other dumb shit they told you, think about this. Your actions have consequences, and following these charlatans is a detrimental action that has lifelong consequences.
Okay. I know that you are kind of caught in the middle of this, that you probably is the first time this has happened to you, correct? Yeah. So,
Your name is again?
Lenka Coloma?
Lenka Coloma?
Yes, that's right.
Okay. And you are not a legal attorney, but you're acting as one?
I am representing Kat Spinda today because of her safety, okay, because I have knowledge of the law, okay, and I'm her next friend, so I'm here on her behalf. Okay, I showed you the power of attorney, that she gave me the power of attorney so I can speak to you today to present you with the court of record, which is a court of record. Everything has been agreed to. Okay, so if you proceed, like I said, you will be selling a fiction today, and so whoever buys that fiction, will be actually defrauded, and this is why we have to have it on a public record, because this is in public arena. Thank you.
So Kat has joined us now. Kat, welcome to the call. Glad you're here. We're just following closely. Oh, Kat just left. It's interesting that they don't want things on record and they don't want to.
Oh, it's becoming a little bit uncomfortable. That's exactly right.
It's also sitting on the
Hi, I'm Kat's friend. I've been trying to teach people.
Hey, Jack.
For 30 years, all the way through.
So it appears the guy that's doing the auction here, the auction's supposed to take place right here. It appears that he got really upset by all the cameras in his face. He's going inside to see what's going on, make a phone call. Which should be a little interesting. It should be an interesting situation going on today. It should be an interesting test as to how this alloidial title thing works. So very excited, interested to see how it's going to go.
Well, I hate to be the one that pisses in your Cheerios, but we don't need to watch the rest of the video because we already know how this is going to work.
I was just walking by and I don't even know what's going on.
Forward in someone else's name, and that's the superior title to the land. Are you aware of the difference between real property and private property, real estate, what real estate is?
Well, we're professionals, and
What kind of professional are
we
you?
do this all the time, so we're
Yeah,
pretty well aware.
I bet. What kind of professional are you?
I'm not going to talk anymore about this.
Why not?
We're making money professionals.
Oh, I see.
The sheriff's seat on the side with the auctioneer.
Okay. You know that there is really no money too, right? Or this is news to you?
We know everything.
Oh, okay,
So,
good.
I wish I did. I know nothing.
Yeah, but I just discovering a lot of things.
You're
here today,
getting to
yeah.
know everything. Sure is.
So you guys buy
They don't
it
have
and then
names
you
either.
flip it. That's what you do? Or?
Sometimes.
No,
We filled out a check. All right, so we did not lock the door.
He's the one standing here in the door. We came here.
We can have you guys back. Guys, give us a second. We're going to do everything, okay? We're just looking at some of the check. Auction. Now you're doing business.
I'm not sure.
Get this done.
I have to qualify my bidders and try to do it with respect. Do you have it on you?
Yeah, let's go look.
I do too. Yeah, I
We
do
have
too.
lots of it.
So
I can show you a little bit. I have a whole lot more where that comes from.
how do we know the value of your gold and silver that
You can check the spot price right now online. It's very easy. It's between $25 and $35 right now.
Real money.
Real money.
Real money.
That's what we deal in.
You're gonna have enough to pay for property?
Absolutely. Offered by the Constitution.
Yeah, I'm not getting, you guys are way out of my price limit.
Yeah, these idiots just tried to buy a house with some silver coins, and they wonder why no one takes them seriously.
So the auctioneer appears very rattled. He's standing inside on the inside. It hasn't gone through security, but standing next to a bunch of sheriffs on the inside there, trying to figure out what's going on. I guess he's asking the sheriffs for their protection, but it's a public hearing, so it's going to be interesting to see how this goes. We got the people over here who are coming to buy, the people who are coming to buy the property. I'm assuming just house flippers. And so they're pretty confused about what's going on too. So this will be a very interesting situation. We're going to see how it goes.
It's all a script. Yeah. It's all a script. We want to hear it all, sir.
Hey, we will.
The whole thing. There's $1 million lien on this property, guys. Just so you know.
And you are buying for fiction.
And you don't want to deal with me.
That's not scaring any of them, these two right here, from buying the home. It's not scaring them. You're not scaring them. They're going to buy it. She's getting up out of there. You're not scaring them. That fake, fraudulent $1 million lien. Sovereign citizens file fictitious liens. They always end up getting removed in court. No, but you're not scaring anyone.
Leave that.
You're super scary.
I'm not trying to scare anybody, sir.
The legal description is as follows. Lot 14, block 2 of the Ridge. Okay, you are going to stop standing behind me. Get up there. You want to record, stand up there.
Oh, thanks for your advice. Didn't need it, though.
Okay. Stay away from me.
Okay.
Now, pursuant to the notice of trust and sale, is duly posted, recorded, same thing. I don't care. Hey, don't get behind me.
Do what you're told. Do what you're told, Chadwick. He's the boss of us. I can't wait. What page was it again? 574? They're all in on it, Marine. I already called the.
As required by the laws of the state, I am offering for sale to the highest bidder for cash or interest. We do not accept cash or
Just say no to drugs.
Does anyone wish to enter a bid? I have 3 qualified bidders. I will entertain bids this time. Do not walk behind me. I'm dead serious, guys. I'm not doing this. Don't walk behind me. You really want to get to be in public.
Apparently not.
You don't walk behind me.
That's hilarious.
You want to know something even more hilarious? Your friend losing her house. And if you're watching the video right now, hit the like button if you think it's hilarious when a sovereign citizen tries to defraud the bank and ends up losing their house instead.
And just for the record, this is what's being sold. It's a fiction, legal description right here, the deed of trust versus the lady, the woman, Kat Espinda owns the land. Please put it on public record. Yes, that's what you are.
If we had a legal issue, we would have stopped it.
That's right.
Okay, time of the opening bid.
For the record. Legal, real, private property, land, soil. People walk on the soil. fictions, persons, corporations.
Look, it's they're both in
deal
on it here.
fiction.
Here's the auction going on. Don't miss it.
That's what they are buying.
What's the current bid?
352,800.
352,000. Just trying to hear.
Hey, son.
Don't touch me. Don't touch me.
Send the sheriff out here now. Hey, this is going to get stupid. Send the sheriff out.
This guy shoved this guy. I saw the whole thing. I have it on tape. This guy in gray. We've got it on tape, sir. That's called assault. We like to press assault charges on this guy immediately. Chadwick, do you want to press assault charges?
Got us on camera?
Yeah, we got the whole thing on camera.
Please have a sheriff's deputy out here. In black. Thank you. So they're shoving into us. You're interfering with the sale. They can video record, but they've got to stay back. People trying to cross in behind me.
That's rude. It's awfully rude, sir.
Got $353.
Mind your manners.
$874.
How is that rude, sir? Yes, sir.
Everything you're doing, you think it's not rude.
Well, you let me know how I'm rude. I'll point it out, but I'm not calling people rats.
Hey, what's this guy doing? He wants to come here and keep on doing in front of me?
So these two are working together behind the auction here. This is their security guard shoving a young man in public, just recording, which is our legal right. This guy shoved this guy. The sheriffs are watching. It's a very tense moment right now.
I'm saying right here. You get away from me now.
These two are working together. They're working inside. This guy would not qualify my funds, and this is a security agent. And these guys back here are also in on it. I've seen about enough here today.
Yeah, me too. So let's head over to Kat Espinda's newly auctioned home and see how she's taking the great news.
And it was streaming live, and I do have a allodial title to this plan, and all you bought was the APN number. So this is being, of course, recorded here. I guess you know him, and yeah. And so just wanted to let you know that you're gonna have problems. You're gonna have problems.
Okay. So.
And this will be all online.
Perfect.
We're going to be exposing see, there's bank fraud going on at Happy Community Credit Union. And I had an $8.3 million lawsuit against Crossbury, against Crossbury, against Ken Hohenberg with Hapo, because they are committing fraud. 100% of my loan came from the Federal Reserve. It didn't come from them. Banking laws.
Right there. Right there. You're all wrong. Your money did not come from the Federal Reserve. The Federal Reserve does not engage in direct consumer lending. They don't use the Federal Reserve for your loans. Your loans are funded through, I don't even know if I should say that, because next week you're going to hear, hey, did you know your loans are funded through this? Based on repeating what I said, but if you look on the channel, 2 years, they've never mentioned it. No, your loans are not funded by the Federal Reserve. And this is the thing about my group. You actually know black and white how your loans are funded. More reason.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. War stories in the fine lines.
Require that you have proof of consideration. They provided no proof, and the federal judge squashed my case because they're all abetting fraud together. So I just want to let you know, also there was $1 million lien put on this home about
doesn't matter. It's fraudulent, fictitious, going to get removed by a court order.
3 days ago. So if you guys try to transfer it, yeah, did you guys do a title search? I hope so.
I think it's good if those guys are committing fraud. I think it's great that you're exposing it.
Yeah.
I think you guys are angry at the wrong people. You know, to be quite honest with you. You
But
know,
we're
so
angry.
I mean,
I'm not angry. I'm just trying to expose the fraud.
Sure.
And
No,
you,
what I
that
mean
you
is
guys are
flashing out.
buying homes because 1 million homes per year.
They always want to take their frustrations out on the people who legally purchased their home because they defaulted because they refused to pay. See, she's already tried to take this out against the banks, but her cases got thrown out. So the next people that they want to take it out on are the people that's coming to purchase the home and take possession of the home because they purchased it.
People are kicked out of their homes and the banks provide $0, nothing. So this is a slavery system, and you guys are participating by buying off of the backs of people who are misfortunate, right? They can roll someone out and 80 years old onto the street because they could own the home outright, but because of property taxes, they can steal their home, oxygen mask, children's out on the street. And this is happening every day in this country. It's a slavery system. And I have a allodial title. You can look on the corners of my property. I posted it. It's been legal notice for 60 days. Nobody rebutted it. No one rebutted it. And so I'm just letting you know. I mean, I was somebody here. I was a CEO in this area for a long time. I've been doing business in this town for 26 years. I've read financial statements. I have proof of fraud from, and if you'd like to watch my show, I actually expose all of the proof online. So everybody in this world, we have people from Washington, D.C., who has actually traveled all the way over here to just make sure that you guys are getting exposed for what you were doing. So your faces are here. What is your name again? What's his name?
Todd Jones.
Todd. And also you hit one of the guys that was recording. Why did you do that?
He's down by assault.
No, literally that was on video. That was literally on video. You guys,
I do seriously though.
Yeah.
I think it's, if you feel like you're being done wrong, I think it's great that you're exposing it.
Yeah.
I do, but I think that you guys are lashing. Not you.
Yeah.
Earlier.
Yeah.
Lashing out the wrong people. That's what I'm saying.
who's wrong? Who's the right people? Can
To
you
lash
remember
out at?
the capo? I already did.
What you had mentioned, that if someone did that to me, that's who I would be lashing out at.
I already did. So $8.3 million lawsuit that you didn't hear about because the Tri-City Herald doesn't report on truth.
Yeah.
They don't report the truth.
So, I agree with you.
Okay, well then there you go. See, I sent them my $8.3 million lawsuit like 4 months ago, but did you see it in the paper? No, you didn't.
I'm going to be honest with you. Her lack of self-awareness deeply satisfies me because I guarantee you that they didn't report on your frivolous lawsuit because they took one look at it and determined that it was better suited for toilet paper instead of newspaper.
I agree. All I'm saying is that Jared's not the bad guy here.
But you guys were both bidding on this house, correct? Both of you? Just you?
Yeah, you didn't. And then
Oh, you were just kind
So
of
how many
hammered?
properties do you own in the county, Todd? Todd, how many properties do you own?
I own plenty of properties, but
I understand completely. Thank you for telling me.
Sure. Anyways, all I'm trying to say is that Jared's not the bad guy here. And I agree with you. If somebody's doing you wrong, if the bank is doing you wrong, I agree. Go after
No,
him.
we did.
100%.
See, we
That's
live in a
good.
crooked system with crooked judges. Joseph Burrows ignored all of my bank fraud. So what does that mean? So if you have a crooked judge, right? And then he puts out a crooked order to have this house go under when I provided all the proof that the bank provided $0, which breaks banking laws and security exchange laws. But see, look what they're doing to Trump. This is a crooked system. They're doing it to him. They're doing it to me. And they're doing it to 1 million people a year when the banks provide $0. So this is a movement of the people. The taxes are closing in on the people. The middle class is getting forced out. People like you are buying homes with certified debt because it's not even cash. There's no money. It's all debt.
I agree. There's corruption all over the world.
Yeah.
There is a ton of corruption in house.
All right. Well, thank you so much.
gentlemen.
Have a great day. But I have a low deal title of this home, so I will be here.
Yeah, sure, you'll be there for the next 20 days, which is the length of time the state of Washington requires a new owner to wait before filing for a writ of eviction following a foreclosure. And don't worry, I already have her in-person court hearing for her eviction, and I'll be bringing that to you in a future video. So if you like today's video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.
Woo-wee! Now, I know that y'all we saw her the aftermath of her, court filings and what was going on with court and things of that nature. But let's take a look. Let's take a look at what was actually filed. Because, we saw them at the courthouse. What was actually filed? Now, this is the lady that was in the red hair that was in court twice. These are her filings. Now, look, regardless of me saying these are sovereign citizen claims, look at the dates. This was filed. Look at this. 2024. They're still trying these 40-year-old claims. Look, it's 2024. 2 years ago. So this is who she filed. Representing herself, Suri Juris. You should have just said pro se. It literally means no different. Suri Juris, representing your own and your own self. It's no different from pro se. But these sovereign citizens, they get so caught up on the semantics games that they actually think these words have a totally different meaning when it has no significance. So she is suing the CEO of Hoppo, the judge. Remember, another reason how you know you're dealing with a sovereign citizen, they always sue the judge that rules against them. When the judge doesn't rule in their favor, the judge is part of the conspiracy now. Sheriff, she's attorneys in, it looks like court officers and sheriffs and pretty much everybody in their face. So, before the court, now remember, Judge Burroughs. So she sued a judge right there. So the judge's attorney is going to respond to this. Before the court are motions to dismiss from Defendant Burroughs, Defendant Myler, Defendant Hohenberg, and Defendant Bertolino. Plaintiff filed a response to the motions as well, and a second motion to recuse. Do you want to know why? I'm assuming why she filed the motion to recuse. The reason why she filed the motion to recuse is because this judge probably did not throw out or grant her the relief all based on what she filed. I told you, any judge that does not rule in their favor, they always want to include them in the suit. That's one of the biggest indicators you're dealing with a sovereign citizen. Remember, sovereign citizen is not the name that gives you the title. It's your filings. So if I could pull out a document from 1982, early 90s, court filings, and these people actually said in court, I'm a sovereign citizen. And then you fast forward to 2026, and a person is filing the same similar documents. I mean, identical. But the thing about them is they're not calling themselves sovereign citizens. How do you think the court is supposed to look at that person? The documents are the same. The ideologies are the same. The rhetoric is the same. The formatting is the same. The arguments are the same. But the judge is not supposed to look at that person as a sovereign citizen just because they denounced the name. The court denied the motion to recuse by separate order. The court has considered all motions and the record is fully informed. For the reasons discussed below, the motion to dismiss are granted. So the defendant's motion was granted. This is the fourth complaint filed by the plaintiff has filed this year. All the claims arise out of debt collection actions taken against plaintiff. Another one. You know when you're dealing with sovereign citizens, when they just keep filing claim after claim after claim. After one claim is denied, they file another one saying the same things. That claim's denied, they'll spark up a new one saying the same things. That's when you know you're dealing with a sovereign citizen. I believe in this case, she's going to be labeled as a vexatious litigant, meaning you keep filing frivolous lawsuits. This is why many sovereign citizens want to go to the administrative way, because they know their claims gets no airtime in court. So they want to do everything administratively. Like that's going to change anything. Plaintiff filed the complaint and motion for temporary restraining order. Hold on, let me go down. In the instant case on November 21st, 2023. The court denied plaintiff's motions for TRO on December 5th. On January 4th, 2024, plaintiff filed a motion to recuse and a motion to restate TRO and a notice of investigation demand. Remember, instead of motions and pleadings, they filed notices and affidavits. The court denied the motion to refuse and motion to reinstate TRO. Defendants, Judge Burroughs, Myler, Hohenberg, and Bertolino have filed motions to dismiss. Plaintiff filed an answer to dismissal and second motion to recuse, which the court construes as a response to the four motions to dismiss, because that was what she was really supposed to do. Defendants have not appeared in the case. Plaintiff contends that defendants have engaged in banking fraud, resulting in plaintiff receiving a notice of foreclosure of her home. So right there, they always start the case off from fraud. They never want to get into how did this all really start, and that's the non-payment. Plaintiff seeks an order postponing all further actions against her in the foreclosure of her home. Plaintiff also contends defendant Croskery engaged in a ruse with defendant Kitty to steal plaintiff's car and alleges defendant Croskery kidnapped her. Remember, kidnap, extortion, fraud, those are a lot of the key terms sovereign citizens like to use with no factual basis to back up those allegations. Plaintiff contends defendant Judge Burroughs and Myers caused an unlawful order to be entered, authorizing the sheriff's department to unlawfully enter plaintiff's home. So remember, the last lady, when the judge issues a legal order authorizing an adverse actions against the sovereign citizen automatically thinks that the judge participated and conspired to violate her rights. Plaintiff contends defendants are conspiring against her. There you go. Told you. Plaintiff alleges that defendant Bertolino has engaged in retaliation against her. Plaintiff also contends that defendant Clark created a warrant that caused plaintiff to be kidnapped and detained against her will. So this is how they word things when the law is being upheld against them. It's always some kidnapping. There's always some. It's never going to say arrested under a lawful warrant. It's always going to be the word kidnapped. To survive a Rule 12b6 motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face, Ashcroft versus Iqbal. Threadbare recitals of elements of a cause of action supported by mere conclusory statements do not suffice. That is exactly what sovereign citizens do. What the Supreme Court said you can't do when you're stating your claim, this is the hallmark of a sovereign citizen. Threadbare recitals. Basically, hey, they took my car and it was fraud and they shouldn't be able to do it, and they violated the law by taking my car. That's an example. And consider a motion to dismiss for failure to state a claim, the court must accept as true all well-pleaded factual allegations and any reasonable inference to be drawn from them. But legal conclusions are not entitled to the same assumption of truth. A complaint must contain either direct or inferential allegations respecting all the material elements necessary to sustain recovery under some viable legal theory. Factual allegations must be enough to raise a right to relief above the speculative level. So that's basically saying they're going to give you the presumption of truth, but you can't speculate. Like, your factual allegations have to be supported by factual evidence. It can't be sovereign citizen affidavits as your evidence. Dismissal can be based on a lack of a cognizable legal theory or the absence of sufficient facts alleged under a cognizable legal theory. Although pro se pleadings are held to less stringent standards than those prepared by attorneys, pro se litigants in an ordinary civil case should not be treated more favorably than parties with attorneys of record. And that is what every sovereign citizen wants, to be treated in a manner that is inconsistent with law or fact. Every sovereign citizen wants the pleadings to be ruled in their favor just because they said it happened. We don't even get into the service. We don't need to get into the service. Yeah, well, basically they're saying that she didn't serve them correctly. That's what they're saying. They weren't served correctly. But either way, let's get to the immunity. And this is why when sovereign citizens file lawsuits, they never consult the federal rules of civil procedure. They file lawsuits based on things like this. Let me show you. This is what they do. Let's see. Hold on. Let's see. Let me show you. Let's see. Let's go. What's one of these sovereign citizen websites? Because this is where they go to do their legal research. This is where they go to do their website. What's one of those sovereign citizen websites? Oh. These are their websites. Oh, they must have took them down. Damn, a lot of these got taken down. See, they won't go here. They'll go to their own little groups to do their studying. Look at this. We'll get back to the case in a second. Self-created bills of exchange. What creditors need to know about the redemption theory scam. Over the past 25 years, consumers have, over the past 25 years. Hold on. Hold on. You mean to tell me a Facebook post saying that your bills of exchange are legitimate and you can file them in the bill of exchange act? You mean to tell me when a lot of people think they just came up with the idea to do a self-created bill of exchange like they're one of the first people to think about, you mean to tell me this is at least a quarter century old? Hold on. You mean to tell me they're a quarter century old? Ain't no way. Over the past 25 years, consumers have used the redemption theory as a basis for fraudulent debt elimination schemes that have become persuasive and widespread on the internet. And it's incredibly important for every type of creditor to understand how to protect their interests against such schemes. The scheme proceeds as follows. Consumers create their own bill of exchange, stating that the U.S. Department of the Treasury or some other third party shall be responsible for paying the debt at hand. The consumers present such bill of exchange as payment to their creditors. The creditors refuse to honor such meaningless pieces of paper, and thus the consumer sues their creditor for the creditor's refusal to accept the bills of exchange as payment. Now, a variation of that ain't nothing different from the money order, self-tendered promissory note, some UCC accord of satisfaction. See, these are the core elements. They just change the method in the mode, but it all has the same ideologies. Another one. Every court that has encountered this scheme has found it to be both one, fraudulent, and two, frivolous. What you guys say about that? What you gotta say about that? Come on. Let me guess. The court is wrong. The government's wrong. The IRS is wrong. Everybody's wrong. So where you going to go to get your claims recognized? Why don't you step into a sovereign citizen's courtroom? Such bills of exchange have been found to not be a valid legal document or tender, and any argument to the contrary is clearly nonsense in almost every detail. Damn, Mensa. Mensa, your students going to take this into court? Your bill of exchange act? Courts have observed that a consumer's use of a bill of exchange to satisfy debts are based on redemption theory, which has been widely rejected by courts across the country. So just because you got into this stuff 2 years ago and you think it's something new and groundbreaking, just remember, it's been these processes been around for 40 years. I know people want to act like they just found out and it's something new and they're so intelligent, but y'all like 40 years late. The redemption theory claims that a person has a split personality, a real person and a fictional person called the straw man. The straw man purportedly came into being when the United States went off the gold standard in 1933 and instead pledged the straw man of its citizens as collateral for the country's national debt. Redemptionists claim that the government has power only over the straw man and not over the live person who remains free. Individuals can free themselves by filing UCC financial statements, thereby acquiring an interest in their straw man. They started filing these UCC statements in the early 90s. Remember Kenyatta Stone with her UCC one? Remember everybody that got to UCC one today? Y'all do realize that's 40 years old. The redemptionists also claim that the government created an exemption account at the U.S. Treasury for each straw man. See, back then, they called it an exemption account. Now they call it a trust or an estate. See, all they do is just change the names. It's all the same frivolous elements. Adherents to the theories believe that by filing a UCC financial statement on themselves, they become a creditor of their straw man's exemption account. They then access the value of that account by issuing a bill of exchange, or sometimes a similar instrument called a sight draft, to a payee who then must look to the Treasury Department for payment, or so the theory claims. Courts have considered redemptionist theory and other similar theories. So the similar theories means you're not calling yourself a sovereign citizen. You're not using a word. You're making sure that you word it differently so it won't get thrown out as sovereign citizen. You're making sure you don't say this and you dance around your real core claims, but the courts see through it and it's nothing more than a variation of the redemption sovereign citizen. Oh, no, let's continue to read. Ooh, wrong one. Let's continue to read. Courts that have considered redemptionist theory, other similar theories, have routinely rejected them as being frivolous and a waste of judicial resources. One court described the redemptionist theory as such, that debtors may issue a bill of exchange requiring the government to pay their debts out of secret trust as being equal part revisionist legal history and conspiracy theory. Courts have consistently found that bills of exchange, notes, and letters of credits supposedly drawn on treasury accounts are not legal tender and are, in fact, nothing more than worthless pieces of paper and are a string of words that sound as though they belong in a legal document, but which in reality are incomprehensible, signifying nothing. And that is the hallmark of all these words, plain salads that they put on their documents. They mean nothing. It is clear to see that courts across the United States are in consensus that any attempt to pay off a debt with a self-created bill of exchange is akin to a conspiracy theory and holds no legal weight. However, even with the court's consistent refusal to recognize such theory, consumers continue to argue the opposite. Therefore, it is imperative that creditors and their attorneys are aware of the existence of such theories and are prepared to protect their clients' interests from these fraudulent schemes. So when you get, because I know someone whose friend used to work at the Midland. Yeah, I know who Midland is. And Midland would send you a letter, a debt collector. Then on the back, it'll say, send correspondence or an instrument tender in satisfaction of the debt to this address. Do you know that he told me weekly they would get thousands of bills of exchange or instruments that says UCC 3104, accord of satisfaction. Do you know that people actually thought that when it has that on the debt collector letter for Midland or all these other companies, that they meant that all you do is just create a negotiable instrument and then put accord and satisfaction? Remember, they all have literal interpretations. Like they no context, no deep dive thought. They literally think that, okay, you just told me to go create a negotiable instrument and put accord and satisfaction under the UCC, and because they're telling me that's what I need to do to pay the debt. No, what they meant was a money order which you exchange the equivalent cash for, not the $1 money order, then you just write the number on there. No, an actual legit money order or check, wire transfer, or something that could be converted into cash. They say that they put thousands of those in the shredder, and their attorneys instructed the like Midland and all these finance companies not to even respond. So when you send that stuff off and you never get a response, that's why. Or the times that they do respond, they tell you it didn't do nothing to pay off the debt. And then that's when the sovereign citizens argue back. Yes, I did. So, yeah. Cincinnati attorney Danielle Betcher regularly advised creditors on emerging consumer defense tactics and fraudulent schemes, helping them stay informed. Yep. And protect the equal landscape. There you go. Yes, sir. Defendant Judge Burroughs contends he is entitled to judicial immunity and immunity under the 11th Amendment. As to judicial immunity, judges are generally immune from civil liability under Section 1983. There are two circumstances in which judges' immunities can be overcome. The actions were not taken in the judge's judicial capacity, and the actions were taken without jurisdiction. Two things that they almost never make that mistake of. And this is why they always think that when they file against the judge, they think the judge didn't have jurisdiction. This is why they do what they do. Here, plaintiff has not alleged facts that would demonstrate defendant Judge Burroughs is not entitled to judicial immunity, because they never do. They never have factual evidence to support their sovereign citizen claims. Defendant Judge Burroughs is also entitled to immunity under the 11th Amendment. An official suit in their official capacity is entitled to 11th Amendment immunity. Pena versus Gardner. Do you think that sovereign citizens actually research case law before they file their claims? Because if she would have did, she would have known that claim would have fell flat on its face. No, sovereign citizens do not do any legal research. Plaintiff does not set forth facts to support a finding. Exception applies. Nor that defendant has waived immunity. Plaintiff's response does not address defendant Judge Burroughs' contention. Just thus, defendant Judge Burroughs is entitled to judicial immunity and immunity under the 11th Amendment as to the claims against him in his official capacity. Subject matter jurisdiction is a major part right here. This is a very important part. Pay attention. Defendants Myler, Hohenberg. Let me scroll down just so I can get a full reading of the page. All right. Defendants Myler, Hohenberg, and Bertolino contend that this case should be dismissed for lack of subject matter jurisdiction. Although plaintiff alleges the court has federal question jurisdiction, it is not clear what federal rights plaintiffs allege have been violated. Once again, what rights? You got to be very technical when you're in court. So basically, what they'll do is they just say their rights were violated. Their federal rights were violated, but they can never pinpoint which right. As discussed in the December 5th order, plaintiff does not clearly set forth a First Amendment claim, and she does not explain how the Fair Debt Collection Practice Act was violated, nor which portions were allegedly violated. And I know y'all thinking, well, why the hell they didn't do that? It's not that they just choose not to do it. It's that their claims are the sovereign citizen claims. Sovereign citizen claims versus claims under the rules of procedure of court are like oil and water. They don't mix. There is no jurisdiction that the court can take over their claims when they're making sovereign citizen claims, because sovereign citizen claims are based in conspiracy and theories, has no factual. You're not going to find any case law that will ever support a sovereign citizen claim. But you know where you can find a plethora of case law to support the claims that I raise in my own case and on behalf of my clients? Want to know where you can find it at?
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
While plaintiff contends she is presenting criminal and civil claims, plaintiff may not bring criminal claims. United States versus Nixon. And yes, the president. Plaintiff also completed the portion of the civil cover sheet that applies to diversity cases. However, she is not presenting any facts to support a finding that diversity jurisdiction exists. And this is one of the downfalls of sovereign citizen and just pro se litigants in general. They do not know how to put a professional legal complaint together where it survives the Rule 12b6 stage. Defendant Hardenberg contends jurisdictional dismissal is appropriate because plaintiff does not allege a coherent, plausible, and non-frivolous claim that provides a basis for jurisdiction. See, with the Supreme Elite Team and the New Culture Empire, we actually provide a coherent, plausible, and non-frivolous claims that provides a basis for jurisdiction. This is why whenever we respond to a complaint or file a complaint, we have yet to get a motion for dismissal under Rule 12b6. It always leads to the civil pretrial stage. Defendants Bertolino and Myler also contend that plaintiff has failed to establish subject matter jurisdiction. Plaintiff's response does not address defendant's contention. And this is the problem with a lot of pro se individuals, especially with the redemption sovereign citizen community. They are so consumed with their own allegations, and some of their responses, they just ramble on about the fraud. They don't even respond to the defendant's contentions. They don't ever see court. You have to respond to the defendant's side. If they file a motion, you have to respond to the motion, setting forth your legal grounds why they should not be granted their Rule 12b6 motion. What people like her do, and they'll just keep they'll just ramble on about their claims. They don't even, and a lot of reason why they do it, because they don't have the legal experience or the knowledge to fight their claims from a legal standpoint. So she runs out of legal stamina here. It's clearly on display. She doesn't know what to say. As plaintiff has not presented facts to support a finding that federal question jurisdiction nor diversity jurisdiction exists, plaintiff has failed to establish that the court has subject matter jurisdiction. Another bomb right here. This right here is why 99% of sovereign citizen and pro se litigants in general never make it past the initial stage, because none of their complaints state a claim upon which relief can be granted. Stating a claim is not you telling the judge what happened and how wrong you was done. Defendants Myler, Hohenberg, and Bertolino contend plaintiff has failed to state a claim. A complaint must contain more than a formulaic recitation of the elements of a cause of action. The complaint must plead enough facts to state a claim to relief that is plausible on its face. Before we get to discovery, just by the face of the complaint, it seems like you stated a claim. This is how bad it is. Even on the face of their complaint, there's nothing that's non-frivolous. Liberally construing the complaint in the light most favorable to plaintiff, the court finds that plaintiff has failed to state a claim upon which relief may be granted. Plaintiff's complaint largely addresses claims of criminal actions and does not set forth any facts to support a civil claim. Want to know why? Because they're so caught up on, fraud and conviction and kidnap, and I'm going to have you arrested. This is how they all think. While plaintiff mentions the First Amendment in the FDCPA, she does not support the bare assertions of violations of her rights. Plaintiff's response does not address defendant's contention. As such, plaintiff has failed to state a claim. Doctrine against claim splitting. Defendant Mala contends in the alternative that claims against him should be dismissed because they are duplicative of plaintiff's prior claim against him. The court need not reach the issue, as the court found plaintiff has failed to establish subject matter jurisdiction and has failed to state a claim. And this is why in my group, we have the acronym. We have the acronym because these are the 4 procedures that you have to get down packed in order to survive the court's initial stage. And you only get those when you are a part of my Supreme Elite Team group. We have a 4-word acronym, 4-letter acronym that sets forth the terms that you need to have. I would have loved to tell y'all live, but throughout the constant years, too many gurus will watch my videos from the clouds, watch my lives from the crowds, go back, dissect my videos, and then the next week you'll hear them regurgitating what I'm saying, all for shock value, because I am content to these people.
You're rocking with the best.
I actually got 13 years of experience of the courtroom and rules of procedure. They only do this online for clicks and views and to try to peddle their little broad, frivolous packages for sale. Plaintiff's complaint lists John Doe's investors as defendants in the caption. The facts section of the complaint does not address the investors. The investors are not identified in any way, and there are no specific allegations as to the investors. The use of John Doe or Jane Doe to identify defendants is disfavored. Plaintiff also lists ET and AL in the complaint action. Plaintiff is using the abbreviation ETAL inappropriately. Oh my God. Plaintiff names additional defendants in the body of the complaint who are not listed in the case caption. It is unclear who the ETAL is intended to apply to. Plaintiff must name all defendants in the caption of the complaint. Failing to name all defendants in the complaint denies the court jurisdiction over the unnamed defendants. Federal Rules of Civil Procedure 10A. And this is the #1 problem. None of them ever want to follow the court rules governing motions and pleadings. They never do. They think their sovereign citizen script is good enough. And you want to know why they don't want to learn the court rules? Because look what they all have to know. Look what they got to study. Look at this. Actions in rem. Look that they have to know. Look at all the stuff they have to know. This is just one section. Let's get to Rule 26, discovery. Look at the discovery rules. So when I get to the discovery stage, this is all the stuff that I have to know. Look at all the rules of discovery. These are all the rules of discovery. We didn't even get into the rules of evidence. These are all the rules of discovery. This is what I have to know. Not only for myself, but for my, my clients. I have to know. I've read all this like 50,000 times. I study this. Look, form of pleadings. Your pleadings have to be in a proper form. Then you got your rule 9, special pleading matters. Right. See? You got to make sure you're following the rules of pleading. And then people wonder why, damn, how come none of their stuff was ever dismissed at the beginning stage? What am I doing so wrong? It's simple. You're not even following the rules. And this is how you object. Defenses and objections. Motions. How to present defenses. Every defense to a claim of relief in any pleading must be asserted in the response of pleading if one is required. But a party may assert the following defenses by motion. Following defenses by motion, not affidavits. You notice they don't say nothing about an affidavit. There ain't nothing about it. Where does it say affidavit? Where does it say a notice? What does it say? By motion, not affidavit. And they wonder why these sovereign citizens lose. It can't even follow simple rules. Look, they can't even follow simple rules. This is elementary. You learned this your first year of law school. See? Motions must be made before pleading. Motions. Motion for judgment on the pleadings. Judgment on the pleadings. Timing. When to file for motion for summary judgment. That's what they're talking about here. Motion for judgment on the pleadings. After the pleadings are closed, but early enough not to delay trial, a party will move for judgment on the pleadings. Talking about summary judgment here. You got to know the timing when to move for a summary judgment. You can't just file one because you want when a thing's considered to be raised. When some are raised, look, preserving certain defenses, you got to know when to raise them in your operative complaint, or you may lose it. When to raise others. Look, lack of subject matter jurisdiction, hearing before trial. Look, and then you got to read the updates. What are the updates? Look, what are the updates? Subpoena order. You got to read the footnotes too. See, want to know why? Because this is what separates the Supreme Elite Team University from everybody else. Most people are going to look at this like, oh, man, I ain't reading all that shit too much. We're going to go the extra mile, the second mile, the third mile, the fourth mile, the fifth mile. Look, commencing the actions, summons. The rules govern summons. When to summons. How do you serve a defendant? How to properly serve it. Look, all this. The courts tell you. The courts tell you when an affidavit is required. They tell you. They even give you a template. Form of action. There you go. Like, that's what I'm saying. That's what I'm saying. But what this right here, see, this is what you're supposed to know right here. Let me show you. All this right here. You're supposed to know all this. Hold on, let's go all the way down. You're supposed to know all this. Go back up. Before you bring your ass into a courtroom. This is what you're supposed to know. This is what lawyers go to school for. They go to school to learn all this. When to apply it. If you, and look at this right here. Now it's the trial. Taking testimony. Look. Now this deals with trial. This deals with trial. This deals with the discovery. Title 4 deals with the parties to the pleading. Title 3 deals with the pleadings and motions, the form, how to do it, how it's done correctly, how it must be presented. And then Title 2 deals with the order, serving. And this is why we are different from everybody else, because they have a teacher that actually knows the court rules and procedures and does everything according to the rules of procedure, not because the redemption theory said this is what it is. This is the difference between me and a lot of people. This is why you can let me see. This is why it's not a surprise when you can see me on the phone with the other party's counsel.
Sure.
Yeah.
I don't have an issue with that.
Okay.
I'll look into that.
Yeah.
And if I don't get it,
Oh, please,
if it's not showing up, I'll let you know.
please let me know ASAP. And just to hash earlier, just like we talked about our positions earlier. I just want to just let credit acceptors know that I'm really open to resolving this matter so we can move on.
Okay.
All right. Thank you.
No, I appreciate that. I'm email. Oh, here it is.
Yep.
Oh, yeah, it's really funny. I'm not getting a bunch of emails. That's a problem.
Wow.
Okay. I'm glad you pointed that out. I have an email from my colleague
Okay.
that really should have come in. So I'm gonna have to close this out and figure out what's going on.
Okay. All right. Thank you.
I'll take a look. I'm just gonna. And by the way, I'm just gonna hit send on this email that I was writing to you.
Okay.
It may be moved by your email.
Okay.
But I'll just hit it since I already tracked it.
All right, perfect. Don't want to not send it. It's perfect. That's cool. I'll take a look at it regardless.
Sounds good, and I'll be back in touch with you soon.
All right. Thank you.
All right. Thanks so much.
Does that sound like a professional correspondence? Oh, don't leave now. Does that sound like a professional dialogue between me and their attorney? Do you think this will be a conversation? What do you think my documents in our community? Do you think I'm doing anything with the sovereign citizen? Doesn't it sound like he's talking to another attorney?
You're rocking with the best.
I got dialogues with professional attorneys all the time. I had a situation last year. I had to resolve for a client, the lawyer. Hey, I sent the order over for you to sign. Hey, oh, you're no, man, I'm not an attorney. I'm just familiar with the case. I'm just representing. Okay, so I'll go through you. I'll talk to you. Hey, I'm sorry I couldn't get back to you, but please, I'll be sending it over in the morning. Oh, email some professional attorney. I'm not new to this. I'm true to this. I got 13 years of experience in the courtrooms and filings and pleadings and motions. I got 13 years experience in this. 13 years experience of in courtroom proceedings, motions. I got 13 years experience. Stamped by professional lawyers. Ex-SEC attorneys stamping my motions and pleadings. This is, and that's the difference between me and everyone else. I was doing this before I even came to YouTube. I was doing this a decade before. I already had results before I even came to these spaces. Plaintiff has failed to state a plausible claim against any of the Doe or unnamed defendants. All defendants except defendant Crosby have been dismissed for the reasons discussed here. Although defendant Crosby has not appeared in the case, the court finds dismissal appropriate. Like, he didn't even have to show up. You want to know why he didn't show up? He didn't show up because he wasn't properly served. So even if, let's say, she would have got a judgment against him, all he was going to do was file a motion under rule, let me see, 55B or rule 60B, 55C or rule 55C or Rule 60B. Let's go down. What did I just say? Rule 55, Rule 55C, or Rule, let's go to 55. What did I say? Rule 55. Bam! Right there. Rule 55C. A court may set aside an entry or default for good cause, and it may set aside a final default judgment under Rule 60B. What did I just say? Either Rule 55C or Rule 60B. Oh my gosh. What did I just say? Look, relief from judgment. Look. Either as party or legal representative from a final judgment for the following reason: mistake, inadvertent, surprise, or excusable neglect, newly discovered evidence, the judgment is void, or any other reason that justifies relief. Told you. What did that say? Even if she would have got judgment against him, he was going to come in with a motion under Rule 55C or Rule 60B and say, hey, I was improperly served, satisfy this. As soon as they would have set aside the judgment, he would have filed a motion to dismiss. I know how court operates. I've been doing this. Surgical with the motions and pleadings now. More the reason why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. War stories in the fine lines.
The court may dismiss a complaint by its own motion for failure to comply with Federal Rules of Civil Procedure, Rule 8. Well, you notice how the judge ain't throw my complaint out under Rule 8. The judge ain't throw my complaint out. As you know, we're still moving along. I was talking to the lawyer today. We're in the stages where we're setting the table for some final resolutions. Trying to resolve this case. And we both agree, like, hey, man, hey, we can get this resolved. He agreed. He said, hey, man, we can get this resolved. I think that'd be better for both parties. If it's not, he said, of course, at least we'll engage in, a little friendly, legal battle. That's what he said. I said, yeah, ain't gonna be nothing personal. I know you're gonna come. I'm gonna come too. Hey, you gonna bring yours? Bring your heat. I'm gonna bring my heat. Shoot, there ain't nothing to it. Ain't nothing to it. Now, what did they say? Rule 8. And Rule 8, you gotta state a short and plain statement about the claims. You can't just ramble off the facts. You got to actually state your claim. That's what this is where people get their case dismissed right here. A pleading that states a claim for relief must contain. This is why I say we do things by the court rules of procedure. Y'all do shit by sovereign citizen rule books. This is why y'all got no relief. This is why you get no remedies. This is why you don't even make it past the initial stage. This is why you're still going to be stuck in the mud in year 2026 because nothing's changed. You're still frivolous. You still have a sovereign citizen mentality. You're still mentally lazy. You still don't want to read. You still don't want to take your time. You still don't want to lick your wounds. You want to be non-accountable. You don't want to be held accountable for nothing you do. You want quick, fast results. You want templates. You want processes so easy that a caveman can do it. You want everything just handed to you on a silver plate because all you watched a timeline, someone saying you can have it all. Oh, you don't have to pay your bills. All debts are prepaid. Now you want it. You've been ignorant 30 years of your life. You wake up, you become woke now. The all-seeing eye, you're so woke now. Now you want it all in a month. 30 years of ignorance is gonna make up for one document, one template. If you don't get the hell out of here. Rule 8 requires a complaint to include a short, plain statement of the claim, and each allegation must be simple, concise, and direct. Well, that's going to be hard because these sovereign citizens love to ramble. And the complaint that is so confusing that its true substance, if any, is well disguised, may be dismissed on the court's own motion. A complaint that fails to provide defendants fair notice of the wrongs they have allegedly committed does not comply with Rule 8. And this is the difference. Yeah, people do the sovereign citizen way, and the sovereign citizen way does not comport with any of the court rules. Yeah. Yeah. Now, this is the rule that everybody right here. This is the rule that very few pro se litigants can ever pass, get by. Look. Right here. In alleging fraud or mistake, a party must state with particularity the circumstances constitute a fraud or mistake. Malice, intent, knowledge, and other conditions of a personal mind may be alleged generally. Right here, Rule 9B. The minute you say fraud, you are subject to a heightened pleading standard. Less than 1% of pro se litigants ever make it on a fraud claim. Rarely ever. Ever. Okay. They got links. Yeah. Pro se litigants generally face very low victory rates, often losing between 80-90% of the time in federal courts, with studies showing pro se plaintiffs running around 3% and defendants around 12% of final judgment, significantly worse than represented parties. This disadvantage is even starker in criminal cases where pro se defendants face much higher conviction rates, illustrating the substantial change of navigating the legal system, challenges of navigating the legal system without a lawyer. In Latin, pro se means for oneself or on one's behalf. In court, pro se means at least one party represents itself without an attorney's assistance. Pro se, okay, we read that. The conference state court administrator found similar trends in pro se litigants across the country. And this study self-represented litigants could disproportionately lose to parties represented by counsel for many reasons. One explanation for this imbalanced outcome is the attorney contingency fee system. Many times, lawyers work on contingency fees based where they receive only when their clients win. Due to this system, lawyers favor representing clients with stronger cases, while parties with weaker cases remain unrepresented. Therefore, pro se litigants may lose more often because they have inherently weak cases that cannot attract lawyers to represent them. Even if lawyers do not operate under contingency fee award, they still may not want to represent frivolous suits that parties go on to litigate pro se and subsequently lose. Under this explanation, a pro se litigant is not inherently disadvantageous to self-represented parties. However, other readers, including a lack of substantial legal knowledge, that is, to me, the number one reason why pro se litigants lose. It's not just the rules and procedures that they don't have down pat. One of the biggest problems is most pro se litigants do not know how to navigate through the nuances and the things that you have to be able to adopt on the fly. You may have to change your game plan on the fly. You may have to change your whole line of questioning on the fly. You may have to switch up your tactics on the fly, something that you can't plan for, but your experience and knowledge kicks in when the situation presents itself. Do you think many people that's been online, these online groups, understands the complexities and nuances of court? No. Lack substantial legal knowledge, courtroom inexperience, trial preparation, emotional attachment. That's another big one. Pro se litigants, they are under the impression that the finance company or the plaintiff did something personally wrong to them. So they file, I call emotional violence. You're mad. You just want to get it out on paper and you miss the bigger picture. And a lot of pro se litigants file emotional lawsuits. I call it retaliatory filings. You sent the sovereign citizen document in. They told you it was not legit. You responded saying it is. They told you it's not legit. Do you want to get on a payment plan? You said no. They gave you a notice of default. You respond with another sovereign citizen process. They give you one last opportunity. You respond with a new sovereign citizen process because every denial, one thing about sovereign citizens, when the first teacher don't work, they immediately jump to the next teacher. Then they go 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 to the next teacher. But all the teacher hopping that they do, no understanding is being had. They're not learning from their mistakes. They're not gaining wisdom and understanding. They never really ever established a foundation. They really don't understand what they're doing. They really don't believe in it. It's just their circumstances and situation in life is starting to make choices for them. They really have no confidence. They don't understand the language. They don't understand the rules. They don't understand the procedure. They don't understand the rules of evidence. They don't understand motions. They don't understand pleadings. They don't understand jury instructions. They don't know cross-examination. They don't know how to ask the questions. They don't know about legal objections. They don't know about none of it. Emotional attachment and more could point to inherent flaws within pro se representation model. Parties without a legal background lose because they lack procedural and substantive legal knowledge. A study in Northern District, California showed 56% of pro se claims were unable to survive even a preliminary motion to dismiss. The same stage that I always say 99.99% of pro se litigants online can never get past the initial stage. Where every single case in 2025 that the new culture empire has taken on, we've all made it to civil pretrial. Whether it's my own, UWM, Velocity, credit acceptance. There was never no Rule 12b-6 motion to dismiss.
You're rocking with the best.
And you know, can't lie about a court case. That's an absolute fact. That's an absolute fact. That's an absolute fact. Matter of fact, let's see. He may be watching now. I'm going to call a random client. Let's call a random client. See if he answers. Let me call a random. I'm gonna call a random client. Let me just do it off the spurt of the moment. Sometimes I do that. I just do just off the spur of the moment. Let's see. He may be watching live. Or he may be at work. Yeah, he may be at work. Yeah, he probably at work. All right. Yeah, I'll catch you later. If you call back, I'll ask the question live. Pro se litigants lose on a preliminary motion to dismiss because they lack knowledge regarding what did we was just going over? The procedural rules, court rules and procedure. They don't study them. They don't know them. Hell, they don't even understand them. And why am I saying all this? The reason why I'm saying all this, because if you do not add court repertoire to your process, you're always going to be a slave to an administrative process, which there's nothing that you have about that administrative process that you can actually enforce in court if they don't acquiesce to the law. If they don't acquiesce, how are you going to enforce? Oh, okay. He just sent me a message. Okay, damn. All right. Yeah, he just sent me a message. Damn. Yeah, so and that's why. And the reason I'm doing that is because if you don't know how to enforce your claims in court in a coherent manner that's not thrown out in the beginning stages, you're always going to find yourself on this hamster wheel of a space under the guise of enforcing your rights, UCC3 group. You're always going to find yourself spinning your wheels, which is more the reason why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume, war stories in the fine lines.
While litigators, oh no, we ain't get that far. They have unfamiliarity with the statutes, case law, and relevant laws directly pertaining to their case, which is a major one. Relevant laws containing directly to their case. So when people like Kenyana Stone says there's no case law on accounting, it's because she doesn't understand case research and law, and she thinks that accounting is tied directly to a consumer contract when it really has nothing to do with it. Accounting is only for financial reporting purposes.
You're rocking with the best.
Oh, they're not going to have case law on this stuff. Why would they want the truth to get out there? If that's so true, then why do I have well over 100 cases of the judges saying in a mortgage foreclosure case the same things that I'm saying? Why do I have evidence in anything? Credit card, I got plenty of case law on that supports what I'm teaching is true. Auto, plenty case. Hold on. Credit card, case law that supports what I'm saying is true. Auto, case law supports what I'm saying is true. Mortgage, case law that support what I'm saying is true. Credit card, case law support what I'm saying is true. Debt buyer, case law that support what I'm saying is true. Student loans, case law that support what I'm saying is true. Bankruptcy, case law that support what I'm saying is true. You pick the subject. I guarantee I got case law on it that supports what I'm saying is true, that aligns directly to the facts of my case or any of my clients' case. I bet you I could find a court, plenty of cases, not just one citation, state law. Hold on. I can provide state law and federal law that supports exactly what I'm saying is true, where the judge is saying exactly the same thing I'm saying, where plenty of mortgage lenders lost their mortgage foreclosure suits for the same reasons that I teach. So they lack unfamiliarity with statutes, case law, and relevant laws directly pertaining to their case. Finding relevant substantive law may even offer little help if pro se litigants are unfamiliar with the language and legal standards to properly utilize substantive law. That is another major point. How do you connect that case to your case? What's the underlying substance of the claim? How does your claim comport with the rules that states a claim upon which relief could be granted while following the procedural posture of the case? And this is the nuances of court that I'm talking about.
You're rocking with the best.
How does your claims, the elements of your case, the facts aligns with the procedural history of that circuit? How does that circuit normally rule on these cases? How do you find cases that align with the procedural precedents of that circuit? So you are right in line with rulings that they rule on consistently, increasing your client's chances of winning the case. And this is the legal nuances that you only learn through experience. Finally, parties without formal legal training have less practice identifying and analyzing legal issues. This is why they all make the same arguments, where the arguments that they're all supposed to be making, they don't even know it exists. Can you imagine? Can you just imagine how many cases I can pull up right now by just typing in this search engine that's going to confirm everything that I'm saying? Can you just imagine? Can you imagine? Can you imagine if I just started how many cases I could just run them off, case after case, just case after case, case after case? Can you just imagine how many? Oh, no, don't trip. Supreme Elite team, no. Anybody watch for the Supreme Elite team, they know. Leading to overlooked issues and imprecise legal arguments, aka failing to state a claim. And one thing about these attorneys, y'all think that these attorneys are going to argue back and forth over your facts of the case. Do you know what's going to happen once they realize you don't understand court rules of procedure? You know what they're going to do? As soon as you make a procedural hiccup, they're going to attack it. As soon as you didn't file this pleading right, they're going to attack it. As soon as you didn't serve them correctly, they're going to attack it. As soon as you didn't respond according to the court rules, they're going to attack it. How do they attack it? They attack it with motion for summary judgment. Yeah, you responded to their motion, but your motion did not hit to the core elements of their claims. Your core elements that you did had nothing to do with the relief that they're requesting. You didn't actually present a legal defense to their claims. You just started rambling on how much fraud they committed. You didn't actually file a motion that sets forth legal and substantial issues with the judge granting them judgment at the beginning stages. No, you just went on how much they're committing fraud and how wrong they did you. So when they realized you didn't respond to the legal standards according to the legal rules and the posture and the procedure, you did not present a genuine issue material fact, and therefore they're going to move for summary judgment. They rarely ever respond to you with the facts. They're going to respond to you procedurally. You think these lawyers don't know when you don't know the procedure? Go ahead and make a procedural error. You ever been at a picnic and you like drop a hot dog or some chips or something, and you look down on the ground, it's like 50,000 ants on it? That's the lawyers to your motions. Leading to overlooked issues and imprecise legal arguments. While a trained attorney may have the same issue, non-trained attorneys will more likely struggle with substantial legal knowledge and analysis without similar experience or practice. While litigators often participate in court proceedings, pro se litigants are less likely to have courtroom experience.
You're rocking with the best.
There's a difference between responding to emotion and arguing it in court. When you respond to emotion, you respond according to the rules. But when you argue your motion in court, that does not mean read your whole motion into the record. The judge already read it. Now you have to argue it. Let me give you an example. I filed a 90-page complaint that passed the court sufficiency stage. If I have to argue it in front of the court, I'm only arguing about 3 or 4 points. So out of 90 pages, I may only be arguing about 7 to 8 pages worth. And that's the difference. That's the nuances in court. Oh yeah, you can, we can type up a motion, put it together, you can file it. The question is, can you actually argue that motion in court? See, that's the difference. And all of this, what I'm saying, which we're infusing professional legal documents into the curriculum, everything that I'm saying will be taught in the university.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Are less likely to have courtroom experience, leading to unfamiliarity with the adversarial process, court rules, and court characters, causing more losses, much like the repeat player effect that claims frequent arbitration participants are most likely to receive better results. Attorneys with experience in courtrooms will ostensibly receive better results than self-represented litigants who may only participate in court once in their lives. Pro se litigants may not know how the court works. And that's what it boils down to. Pro se litigants have this wild, outstanding, landish theory on how the court works. But I'm going to tell you this from experience. Court operates in a manner that is 100% different than what you was told or how you believe it operates. 98% of court is about the rules and procedure. The other 2% is about the facts of your case. Which forms pro se litigants may not know how the court works, which forms to fill out, or how to submit evidence, as each judge may have different preferences for procedures or arguments. Pro se litigants will also have less chance of knowing these court rules than an experienced attorney. Attorneys with relationship with judges or people at the court may also know how to cater arguments to that specific person and increase chances of success. Yes, different judges have their different ways of doing things. Yes, represented parties may then use how judges tend to rule in their advantage. Remember when I'm saying, besides the arguments, knowing how the court consistently rules in manners like this, knowing the procedural history of this court, how does this judge rule consistently? That's what I was saying earlier before we even got to the stage. Like, all that has to be taken into account. But these are the things that don't show up in the rule books in court. These are the things that you're only going to know through experience. And represent parties may then use how the judge tend to rule to their advantage. None of these possibilities are guaranteed advantages in every case, but still can make a difference. Pro se litigants must spend time learning all these details about courtrooms, which takes time away from preparing for trials, aka the nuances of court. There are things, and this is gonna be this is the part right here. Woo! Pro se litigants may have difficulty preparing for trial. Voir jury instructions, proposed orders. Pro se litigants, most of them online, they'll file their motions, they'll file their documents. They don't even have proposed orders attached to it. Do you know what a proposed order is? It's a proposed order granting your motion. So if the judge grants your motion, they could just sign the order. Can you imagine how these sovereign citizens' proposed orders will look? And can you imagine? Just think about what a proposed order for a sovereign citizen would look like. Pro se litigants have difficulty preparing for trials. After learning the substantial law and courtroom procedure, pro se litigants must then consider how to examine witness, gather evidence, closely read documents, and present information to a jury, how to submit evidence, how to object evidence, the rules. Oh yeah, y'all. Oh, I forgot. Hold on. I forgot. My bad. We only did the federal rules of civil procedure. You know another thing that we got to know? The rules of evidence. Rules of evidence. Now these are rules of evidence. We got to learn the rules of evidence now. Preliminary questions. They bring in an expert witness. You got to know how to question them. And people thought I was born when I had these hard book copies and all I did was just read these books, take notes. People thought I was born. Look, rules of evidence. Judicial notice of adjudicative facts. Knowing when to ask a court to take judicial notice of. Instructing the jury. How to instruct the jury. Presumption in all civil cases. These are the rules. These are the rules of evidence. Character, wrongdoers, pleas, discussions, related statements. Right here. These are the rules of evidence. And then once hold on. Once I study that, you forgot? All the federal courts got their own local rules. They got their own local rules. Now I got to know the local rules of the court. Now I got to know all the local rules. So I got to learn the federal rules of civil procedure, federal rules of evidence, and the local rules. Look, these are all the local rules. These are all the local rules I got to know now. Look, now I got to learn all the local rules. Another 98 pages. Motion, continuous, orders. How to pull it, how to file it. Forgot about that. Forgot to inform y'all that. Now let me explain something to you right quick. Let me explain something to you right quick. Now, y'all, these are the admiralty rules, y'all. These are admiralty rules. Admiralties and maritime claims within the meaning of Rule 9H. Respect to, look, these whether within admiralty or maritime jurisdiction or not, y'all, this doesn't mean that when you step in why do you think they have their own special rules? Because these are rules for admiralty. Like, they have their own rules. Right here. They got their own procedure for arrest and attachment under admiralty law. Not the admiralty law that most sovereign citizens think. No. They got their own rules, their own laws. United States Prime Maritime Action. Look, statutory exempting vessels. See what I'm saying? Boats and stuff. All that. Boats. Admiralty, docks, ships. Action is a vessel or tangible property on board a vessel. Right. This has nothing. This is dealing with marine, like maritime, like yachts, boats. That has nothing. So when y'all say this Admiralty Court, this has nothing to do with what they mean. These are actually talking about actual vessels that are on waters. Claims that's dealing with boats and stuff on the sea. Hey, this boat ran into my boat. I'm suing you on court. These are the special rules for that. This has nothing to do with a normal civil case like in a mortgage or auto. Totally different set of rules. Now, do y'all understand what I mean when they say Admiralty? They don't know what the hell they talking about. Totally different. I swear to God, I'm not lying to you. In any of my case, my client's case, you know, I never brought up the word Admiralty not one time or maritime. If I don't bring it up, y'all don't bring it up. Nah, it's getting to that point. If I don't bring it up, y'all don't bring it up. Additionally, emotions may hinder a pro se litigant's objective opinion, causing a party to make less rational decisions and damage the outcomes of his case. And this is why I call it, they do a lot of emotional violence. They're too emotionally involved. They're only filing a lawsuit because they got their car repossessed. In a study testing emotional responses to litigations, researchers found that different emotions lead to different behavior in litigations. One example was anger or pride leading to higher frequency of trials when a settlement can have been reasonable. With issues that are personal and sensitive, parties have difficulty maintaining an objective perspective, affecting the party's judgment. This is the mindset of sovereign citizens. They're always prideful. They know it all. They know it all. Nobody can tell them anything that's different from what they believe. And they're hard-headed and they're too headstrong. And all they do is putting themselves in a tighter spot. And when they're put in that tighter spot, then it's a conspiracy. Parties have difficulty maintaining objective perspective, affecting the party's judgment. Counsel can provide objective analysis and sound advice to prevent parties' emotions from influencing litigation outcomes. So one of the reasons how I know I'm dealing with a sovereign citizen over the phone, I'm dealing with a sovereign citizen when I give them an objective opinion on the case and they automatically want to start shutting it down because I'm not telling them what they want to hear. 1 second, y'all.
You're rocking with the best.
Started out with a stack of bills, hand-me-down suit, no fancy skills. Library card, late nights, cheap coffee, highlighting on every page he copied. No letters on the wall, just notes on the floor. Scratch math running down the old front door. Every question that the others let fade, he turned into a rule and a plan he made. Time to start to teacher, build it all from broken pieces. Read the books, the words got weaker. Turn confusion into secret.
You're rocking with the best.
Who's the man behind the speakers? Tell them that's my quiet leader. Time to start to teaching. Yeah. He can turn a red line black in a week. Balance out the numbers while he barely speaks. Spreadsheets open like a map of his mind. Sees a hidden pattern where the rest go blind. Court dates circled in a second-hand phone. Drafts every filing like it's carved in stone. Plain white paper, but the case shines through. Judge starts seeing what he already knew. Time to start to teacher. Build it off from broken pieces. Read the codes, the words got clearer. Found the cracks and closed the leaks in. taught the teacher's teacher. Oh, no cap, no cap, no cap.
You're rocking with the best.
But he wrote every page. Self-taught, self-made, self-drive. That fire turned out into something higher. We don't just follow, we climb behind him. He draws a map, we rise inside it. Thomas taught the teacher's teacher. Build it off of broken pieces. Turn those late night scrolls and research into freedom, into defense. When they ask who shapes the future, who we call when things get deeper, we just point and say our leader. Thomas taught the
All right, y'all back, and I think that's enough for the day. I think we've made our point. I think we made our point. I was gonna air this other video, but I think I'm gonna say that for next time. So, like I said, everything it's not gonna be easy when you stepping in these courtrooms, and especially when you have no experience. No one is saying go try to learn all the court rules at one time. What I did was I broke it down into sections. That's the first thing I did. I said, okay, let me, I want to learn the court rules. So what's the first thing I'm gonna do? Okay, let me learn the rules of pleadings. Let me learn the rules of motions. Let me learn the rules of how to state a claim, service. Let me break it down in sections. And then once I did the rules of procedure, did to the local rules. But it's not just the rules, it's the case law, it's the legal reasonings. Like, not even that. I read publishings from judges, professional lawyers, college professors, like the whole, like jurisprudence, just getting a whole feel of the judicial system and how the system has evolved through over the years. Even the case where they took federal common law and you can't do forum shopping anymore. State law, another thing. Everybody continues to cite UCC. The UCC is not common law. UCC is statutory law. The UCC is statutory law. Why is it statutory law? Because every state has adopted its own version of the UCC and has codified it in their statutes. So when you go to court saying UCC is common law, you are showing the court your ignorance, and the other side knows, because the UCC every state has their own version, and they have been incorporated into the state statutes. So everybody's sitting here citing, let me tell you what they'll cite some generic version of the UCC. They'll cite that. But what they don't do is cite their own state laws equivalents, because, be honest with you, sometimes the state law equivalent is different from the generic DC code. Y'all citing the UCC DC code. You got to cite your state law. So if you got to cite your state law UCC, then that means the UCC is statutory law, not common law. And that is one of the biggest, like those little things. When I hear people say that I'm under common law, the UCC, that lets me know they don't understand court. Because every professional, and y'all heard it. Y'all heard me. Y'all heard me on the phone with the lawyer. Y'all heard me on the phone with the lawyer. Y'all heard me. There's nothing about that conversation that would give you the indication that that lawyer is talking to a rookie. How he's talking to someone. There's nothing about that conversation at all. You go back and play it again. It was at the beginning. We just played. There's nothing about that conversation. I talk to professional attorneys like all the time. We always have these same like dialogues. And I'm in a position now with my own case where me and the other side are opening the doors. We're talking about formal resolution. Because one thing that you got to know about court,
unless it's a major case and they did some major damage, if there's a way to settle, you ain't got to waste time and expenses. Settle. If they're willing to settle, I'm going to settle. Because at the end of the day, when you're bringing up claims in these magnitudes, I don't give a hoot nanny to how effective your claim is. I don't even care if I got them dead to rights. One of the things that you always going to have to remember, no one pro se litigant is bigger than the system. None of us are bigger than the system. By coming out and just saying fraud, you got to understand the way our loans are funded. It's not, first of all, it's not funded through the banks. We just gonna stop that. And you know what's so crazy about that is that's a matter of public awareness. Like everybody on Wall Street knows that. Everybody on Wall Street knows how loans are funded. But we come down to sovereign citizen social media, everybody got the Federal Reserve in the equation. And the Federal Reserve Bank does not deal in active lending to consumers. The banks do not take their Wells Fargo or JP Morgan or Morgan Chase. They don't take your application to the Federal Reserve. Want to know why? Because there's no need to. No, the banks don't engage in active lending because they are not required to. Do you not think under the National Currency Act, 1864, banks can't hold property for more than 5 years? Banks can't engage in their own investing for their own account. Do you not think these people ain't find a loophole to get around it? No, they're not technically lending you the money from their balance sheet. They found a way to get around it. And they're doing it the correct way. So they're not violating 12 USC about lending and all that. They're not violating. And that's the part where y'all getting it wrong. They're not going to tell you this. They're not violating the statute. They found a way to do it another way. And that's how they've been doing it for 50 years. No, they don't need the wet ink signature. They don't need to produce that anymore. Once you sign it, you are signing in an electronic form. If you didn't want to sign it that way, then you would have never signed the application or the deed of trust that way. No, once you sign the application, it is a known fact that that home is going to serve as security for the repayment of the debt by your agreement on the application. So you're bringing up claims which is contradicting what you already admitted when you signed the application. It's right there on and this is why, if you would, a lot of things that I say, people are not reading because they want to be told what to do. They want to be told how to think. They want to be told where to research. They always feel like they have to be told what to do instead of building up the information and knowledge and foundation where they are confident and can stand on their own too. That's what the Supreme Elite team does. I don't have a bunch of people follow me, my core members follow me, just so I can tell them what to do next. I'm teaching them how to think on their own, anticipating on their own, giving them all the recipes. You make your dinner. You're never going to survive. I always waited for someone to tell you what to do next. I lay a hell of a foundation. Every person that's followed that foundation has the ability to build their own path from it. You don't have to follow me directly 100%. The foundation I set for myself, the foundation I use is the foundation I give to everybody else. You can build your own house off it. Your house don't gotta look like mine. It's still gonna end up at the same spot because one thing about me, it doesn't matter whether it's a mortgage, auto, credit card, student loan, bankruptcy. It don't matter what the situation is. One thing, all of the core elements that I teach are going to be prevalent And no matter what the situation is, all the core, if there's, prime example, so if there's a mortgage case, all the core elements that I teach is going to be evident in the mortgage. Hey, auto, no difference in the tactics. All the core elements are still present. I have court cases. What I teach is no matter what the venue is, every court and every judge are still going to be saying the same things that I teach. Regardless if it's a mortgage, auto, credit card, student loan, they're all still saying the same thing. In the context of an auto loan, still saying the same thing. Context of a mortgage, still saying the same thing. You don't ever have to learn a whole new strategy just because you was dealing with a mortgage, now you're dealing with an auto. See, with these teachers, you got to learn a whole new process next week. Me, the core elements never change. They never change. They're the same, and they're applicable in all these situations. And this is another reason why people don't get foundations, because they always got to learn something new every week. They don't know how to establish a core foundation, and then they build off that without changing the foundation. And I'm telling you this, you don't got to believe me or not, but if you don't establish a solid foundation, you're just going to be a process chaser. Yes. You filed this, you've done this, you've done that, you submitted this, you submitted that, you filed that. But ask yourself, during all those acts that you did, what part of those did you ever fully understand? What foundation did you ever really, because there's a difference between just doing the process and understanding the system. See, I don't teach processes. I teach understanding of the system. A broader scope, the system itself, not a process for this singular debt. So, hey, you can do whatever you want, but I'm just going to tell you this. If whatever they told you, they lied to you. They lied to you. No, I'm telling you, they lied to you. They lied to you. They lied to you. They lied to you, and they told you something that wasn't factually true. Now, before I go, I just want to make sure I want to make sure I have it set up correctly. But I will say this. Let me share my screen one more time. Let me show y'all this. And this is why I don't understand why these people come online teaching this stuff and peddling this stuff when it's like you can, it's you know a lot of stuff that I say, I'm like, if you have an objective reality, you're really trying to understand the system, why would you close yourself off to doing all the stuff that they've been doing for 40 years? Like, you ain't never adopted an alternative way. Like right here, does the Federal Reserve engage in consumer lender? No, the Federal Reserve does not engage in direct consumer lending like mortgages and car. Instead, it acts as a lender of last resort to banks and focus on monetary payments. You get what I'm saying? Like, that's what I'm saying. Like, and it's not just, it's like you can go right to their website. Like, you can go to their website and they don't look right here. Despite the name, the Federal Reserve banks do not carry on any banking activities. Like mortgage, autos. Remember I said earlier, they only lend like short-term liquidity, like within 24 hours. If you couldn't find any other sources of funding, that's when they step in, and you got to collateralize it just like any other lender would. But the people that actually still thinks that the Federal Reserve Bank like is engaged in direct consumer lending is dangerous, because a lot of these sovereign citizens, they have a misunderstanding of the financial system because they don't know how to remove beliefs from objectivity. Everything that they do, it's always going to be tied to a belief. Leave your belief systems at the door and research for what it is, regardless of, damn, I've been studying this stuff for years. Who cares if you've been studying it wrong? At least you know you've been wrong, so now you are aware and you can do something about it. But if you know you've been doing it wrong and you still do it, then don't blame nobody else for your outcomes. Blame yourself. Because now you have been warned. The Federal Reserve Bank does not engage in direct consumer lending. That's not even a part. It's not even a part of their powers. It's not even a part of what they do. Right there. Despite their name, Federal Reserve banks do not carry out any banking activities with one limited exception. The Fed traditionally acts as lender of last resort by making short-term collateralized loans to banks through its discount window. Fed set the discount rate on these loans at the top of the federal funds rate range. In the normal market conditions, the Fed's lending operations are minimal. Look, in normal market conditions, the Fed's lending operations are minimum. They're barely involved. But if there's like a run on the banks or a crash, like, oh, then they'll step in and help the banks and stuff. But this is not even like, I'm not even saying anything spectacular because everybody on Wall Street knows this. Like all the professionals I talk to knows this. Like this in my everyday life with these people, this is never even a conversation. It's like, to be honest with you, it's a matter of public knowledge. It's really a matter of public knowledge. So if you didn't know this, it's like it's a good reality check because it actually lets you know like where you think you are and versus where you're really at. See, most people think they really understand what's going on, but when they talk to people like me and like those professionals that really understand the system, they realize they know very little of a system they think they understand. Like they know very little. Even your gurus out here, they know very little of the system, and it's evident in the stuff that they post online. The reason why I get blocked and the reason why they hate when I come around is because they know everything they say on the panel, I'm going to question them. Like they used to not being questioned. You can't question the teachers because they're so used to everybody being so uninformed that they can't even decipher when the teacher's misleading them. They won't even know. And you ain't got to take my advice. Listen, don't believe nothing that I'm saying. I don't want you to believe what I'm saying on face value. I tell my group that. Nah, don't believe what I'm saying. You're going to confirm it. See, but the thing about me, the only place where you can go confirm my stuff is like professional like documents, like deep dive research. You're not going to confirm what I'm saying by you still having the same mindset and going to your normal places to research. The confirmation bias research. This is why I don't ever try to convince anyone. Because most people, they want me to appeal to their belief system instead of taking in the objective facts and looking at it for what it is. Most people want to try to get me to convince them that what they believe isn't true. And I tell them, you don't need me to convince you. Just look at your outcomes. You're nowhere near closer in 2026 than you was in 2025, than you was in 2024, than you was in 2023, than you was in 2022. That's enough conviction alone. I mean, I'm just be honest. I'm gonna joke with this one. What else do you have to lose? You ain't got shit else. You ain't got shit else to lose. You ain't got shit else to lose. I swear to God, you ain't got nothing else to lose. At least, one thing I would say this, at least with the Supreme Elite team, at least I'm confident that I will at least show you the core elements and things that you would need to know that you didn't even know exist. A lot of people say that, but I guarantee you, 99.7% of the Supreme Elite Team University are going to be things that you don't even know exist. And these are the things that you have to know to be on their level. I guarantee everybody said, oh, yeah, I know. Until they sit down like, damn, I thought I knew. Like, I got to think. The people I got on my team behind the scenes, like, these people work in the top levels of financing, in corporate financing. Some of the stuff I know, you would never know unless you actually work for these companies, unless you process payments for these companies, unless you worked in their securitization in that area. You would never know because it's never made public and they never talk about it publicly. So it's like I kind of got an advantage. That's why I don't come out and say a lot of things online. But I'm not telling you something it's not just my research. That's a big part of it. But my research has been confirmed by top professionals. And it plays out in court cases in my court system and dealing with these courts. Because a lot of things, even in discovery, like you're not going to, it's just certain things that I know that you're not going to know unless you've been on that side. That's the fairest way I could put it, which is more reason why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine line.
All right, y'all. Y'all know what it is. New culture. We are in the building and we are signing out.
Empire Talk, Boardroom Aura, new culture. We set order. Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine line. Supreme elate, circle around the table, every seated throne. Consumer finance in his bloodstream, built it from a student loan. He can read a balance sheet like a judge retone. See the trap in every clause before the ink is dried on. They sell dreams on installments, he just ordered the spell. Break a predatory scheme down to decimal hell. Securitization flow, turn a contract to a bond chain. He can trace the money trail backwards in a rainstorm. Same lane, receipts in a briefcase, dates, times, bank names. You bring vibes to the courtroom, he bring numbers in case names. Supreme elite, we don't speak, we file. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. With these Supreme elite, we don't speak, we file. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. Breathe with these. He's seen lenders flip scripts, turn a whip to a shackle. Interest climbing every month to your paycheck battle. But he peeled back price and APR under the mask. See the spread versus the funding, who's skimming off the past. He no chalk off, roll rates, lost curves in his sleep. How they package up defaults and sell pain on Wall Street. He cross-check statements with the filings in the forecast. Find a misstep and turn one comma to a court clash. Consumer on the stand, heart racing in the cheap suit. He translate legalese to plain talk, clean truth. Litigation in his left hand, excel in his right. Tell the judge what the bank did, cell by cell, line by line. Supreme elite, we don't speak, we file. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. Breathe with ease. Supreme elite, we don't speak, we file. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. Breathe with ease. They move in the margins, he read in between. They hide it in footnotes, he pull it on screen. From the boroughs to the boardroom, same concrete. Thomas built a whole empire off one word, receive. Pay vision, JD rhythm in his cadence. Double check the debits, then dismantle all the plaintiffs. Underrated models, he can see where they cheat. Assumptions too rosy on a loss rate sheet. Dockets on the desk, he align them like a chessboard. Case law, cash flows, every step, next chord. Supreme elite follow, blueprints not gossip, they talk bag. He talk tax, keep profit, new culture empire. This is financial defense, teaching credit as a weapon, not a lifelong sentence. From credit acceptance battles to the hallways of appeal, Thomas turned every closed door to a signed, sealed deal. Supreme elite, we don't speak, we file. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. Breathe with ease. Supreme elite, we don't speak, we file. He got receipts line by line, no smile. In the dark where they hide those fees, we light up the fee sheet. Breathe with ease.
up, running in bang. Whipping up heat, got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, I can't glance. You look like you wanna let go straight. What's up? I thought so, okay. I'm back in this symphony, stuck on the band. What's up? I thought so, okay, yeah. Run it up, running it back, whipping up heat.
Bring that one back from the top. You're rocking with the best. You're rocking with the best.
Run it up, running in bang. Whipping up heat, got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, I can't glance. You look like you wanna let go straight. What's up? I thought so, okay. I'm back in this symphony, stuck on the band. What's up? I thought so, okay, yeah. Run it up, running it bang. Whipping up heat, got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf on global band. It's bang. Fresh white tee, chrome on the rim. Big body slide, whole block looks slim. Wrist on chill, but the boy too hot. Turn my last L to a key to the spot. Plug on the phone, said say let's slide. Came from the back, now we front row live. Couch full of cash, can't sit, can't fold. Used to pray for a play, now it's overload. Run it up, running bang bang. Whipping up heat, got sauce in my hand. She rolling the dice, got luck in that van. Spinning that leaf, going global. Expand, blue. Shorty too thick, attitude too. Say she want a boss, not a boy in the crew. Stamp my name on the side of her glass. Says she feel safe when I'm hitting the gas. Mama in the crib, fridge stay packed. All them long nights, put food in the stack. Talk about stay down, I really did that. From the floor to the floor type check. Had nothing but hope in a half tank. Now it's 10 toes down, all gas. No thanks, if they cross that line, it's a bad move. We don't double back, we just improve. Run it up, running big rain. Whipping up heat, got sauce in my hand. She rolling the dice, got looking at van. Smoking that leaf, going global. Expand.
You're rocking with the best. You're
It's lit. Okay, I'm almost wasted and my drip is on a spaceship. One more sip, yes I can taste it. Come to my exact location. I'm so tired of my probation. Doing time for real vacation. I just toasted this occasion to give myself standing ovation. What I'm drinking, that brown, that white, up with the bar sirs. That ass is attractive like a magnet. I never dodged her. Why drink my problems away? And that alcohol is my sponsor. And I will indulge it to the point of death. That's only if my heart hurts. Cause relationships never last. And being faithful is a thing of the past. Everybody's only after one thing. Both sexes can relate to that. Can we place a bed when I hit it from the back? Get your face in my pillow when I palm on your ass. Yeah, I graduated from the bottom of my class. Now I'm sitting at the top. You see the bottom of my glass. We can keep talking. I know this won't last.